ಡಿಸ್ಪ್ಲೇ ಬರಲ್ವಾ?
ಏನು ಬರಲ್ಲ.
ನೋ ಸಿಟ್ಟಿಂಗ್
ಏನು ಬರಲ್ಲ.
ಸರ್ ಡಿಸ್ಪ್ಲೇ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಅಡ್ವೊಕೇಟ್ ಸೀಟ್ ಅಪಿಯರ್ ಆಗ್ಬಿಡಿ ಫಿಸಿಕಲಿ
ತೋರ್ಸಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್.
ಹಲೋ, ಇಲ್ಲ ಅನೌನ್ಸ್ಮೆಂಟ್ ಮಾಡಿ. ಹಲೋ ಸರ್. ಹಲೋ, ಯಾರು ಒಬ್ರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ವಾ? Sir, those who are connected in VC, sir, today some technical problem in internet that display can't be shown. Please cooperate.
Hello.
Sir, ಅದು net issues ಇದೆ, display work ಆಗ್ತಾ ಇಲ್ಲ.
ನಮ್ದು ಫೋರ್ತ್ ಮ್ಯಾಟರ್ ಇದೆ, ಏನ್ ಮಾಡೋದು?
ಮೇಡಮ್ ಕರಿತೀವಿ ನಾವು, ನೀವು ಫಾಲೋ ಅಪ್ ಮಾಡ್ಕೋಬೇಕು. You can't rely on the display because display is not working properly.
Whether it will be adjourned?
ಕರಿತೀವಿ ಕೇಸ್ ಕರಿತೀವಿ.
ಸದಾನಂದ ಅವರೇ, ಒಂದು ಡೇಟ್ ಫೈಲ್ ಇದೆ
ನಾಳೆದಾ?
ಆಮೇಲೆ ಬಂದ್ರೆ ಹೇಳಿ.
ಫೈನಲ್ ಇಯರಿಂಗ್ ಅದು ಅಥವಾ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ
ನಿನ್ನೆ
ಅದೇ ಪಿ ಬಿ ರಾಜು ಅವ್ರದ್ದು.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಎಷ್ಟು ಆದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟಿಗೆ ಹೋಗ್ತೀರಾ?
ಹೌದು, ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಎಂಟೈರ್ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾ? ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಹೌದು ಸರ್. ಅದೇ ತರ
ಒಂದು 20 ಇದೆಯಲ್ಲ, ಒಂದು 25 ಫಸ್ಟ್ ಲಿಸ್ಟ್.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ 24 ಇದೆ.
ಸೊ 24 ಆದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಷ್ಟಾದ್ರೆ ಸಾಕು. ಸೊ ಅವ್ರ ಮೈನ್ ವಿಲ್ ಬಿ
ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್.
ಮೇಡಮ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಫೋರ್ತ್ ಮ್ಯಾಟರ್ ಮೇಡಮ್.
ವೇಟ್ ಮಾಡಿ ಸರ್, ಕರಿತೀವಿ. ಏನಾ?
ಹಲೋ, ನಮಸ್ತೆ. ನಾನು ಸುಗುಣ ರೆಡ್ಡಿ ಅಂತ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ. ಹಲೋ, ಸುಗುಣ ರೆಡ್ಡಿ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ.
Yes, the same second appeal. I filed an application for vacating stay. But the trial court, on an application filed under Order 7 Rule 11, the plaint was rejected, as against which I filed an appeal before the district court. District court allowed my appeal and remanded the matter to the trial court, as against which this second appeal is filed by the other side, and stay is obtained.
When does it?
It was in 2021. I have filed an application for vacating. Anytime subject to your lordship's convenience.
List that matter on 28th of April.
28th of April. Page wise adjournment.
Yes.
ಇದರಲ್ಲಿ ಅಪೆಲೆಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ MBC ಕೇಸಲ್ಲಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಹಾಸ್ಪಿಟಲ್ ಎಮರ್ಜೆನ್ಸಿ ಇದೆ, ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೋಬೇಕು.
The appellant has deposited the money.
Which year?
2021.
2021.
21 matter, you're moving in 25 and you say that there is urgency. No, I'm not taking up 21 matters. You will give this, yes.
My lord, it's a transfer matter, my lord. Yesterday it was listed in the list 3, my lord. But then the date was given as 9/4/2025, my lord. It would be better if earlier date would be given, my lord.
Tomorrow.
22.
Take that.
Number.
22 matter.
Huh?
22 matter ಇದೆ.
Much obliged, my lord.
ಹೆಲ್ತ್ ಇಶ್ಯೂ ಇದೆ. ಹೆಲ್ತ್ ಇಶ್ಯೂ ಇದೆ. ಸೊ ಮೂವ್ ಮಾಡಿ.
22 year.
What is that?
Claimant appeal, sir. MFA na.
MFA.
That MFA claimant appeal is having some MCQ.
Just it on
Plus ಇರೋದು
15.
ಇದೊಂದೇ ಮೇಡಮ್.
ಅದೇ
ಇದು ನಮ್ಮ ಕೊಲಿಗ್
17 22
Yes.
months.
ಅಲ್ಲ, serial number 6.
We'll call.
Page-wise adjournment, list 1, page number 6, serial number 17, 18, page number 17, 19 to 20, serial number, page number 8, 21, 22, page number 9, 23, 24, list number 2, page number 5, serial number 14 to 17, page number 6, 18, page, list number 1, serial number 1 for admission, Vijay Krishna Bhatt for appellant,
My lord,
A. Venkatesh.
list was submission, my lord. List number 2, serial number 10, my lord. Raised for time. It may be posted for tomorrow, my lord. The advocate on record is not in station. So he requested me to pray for time.
It just, it's coming up for orders, that's why they are not called.
Yeah.
We'll not pass any order, adverse orders. Any application to be ordered, we'll order. And we'll give a date.
Kindly, he
It
requested me
says,
to post it for
avoid
tomorrow.
service of notice in respect of R2 and R3.
Yes, my lord. Yeah, please. Yeah.
So
Yes.
that's what, nothing will be done, please wait. Yes.
One short date may be given, my lord. One short.
After that, looking at that, then we will do. Yes, one.
List number 1 for admission, serial number 1, Krishna Bhatt for appellant, A. Venkatesh.
I pay for appellant. For this case of injury, my lord. Minor boy, my lord, aged about 3 years, met with an accident and sustained fracture of right humerus. Lord,
What was the amount granted?
43,500.
What was claimed?
Claimed, my lord, 5,65,000.
Any disability?
Disability assessed by the doctor is 10%.
The
The
whole body?
right upper limb.
Only limb.
Right
Only
upper
limb.
limb, but disability certificate in the say it is permanent in nature. 10% is permanent in nature.
And to the whole body, how much?
Whole body he has not stated.
So then even if you take it, one third of it, how much it would be?
3%.
3%.
Considering the nature of injury, my lord, also it's a fracture of.
Please come to the calculation.
Please, my lord.
Page number?
Page number, internal page, judgment page number 8, ink page number
Table?
14.
Table. No table.
No table.
There is
my
no
lord.
table, my lord.
In your synopsis, it must be there.
Yes, my lord. Page number 2, my lord. Whereas loss of amenities, 20,000 has been awarded. Pain and suffering, 10,000.
Pain and suffering is a one fracture.
One fracture, 10,000
Yes.
has been awarded. Amenities for 20,000 awarded.
Amenities
Compensation
is
towards-
rightly granted. Amenities, no requirement to enhance it.
Lord, my humble submission would be, my lord, as per the decision of Master Mallikarjun, passed by, my lord, the Honorable Apex Court, and the latest, my lord, I may proceed, your lordship, to this judgment, my lord.
To that.
It's a recent judgment, my lord, passed by the coordinate bench of this Honorable Court, my lord, where, my lord, this Honorable Court has considered that depending upon the, my lord, the inflation of annual inflation, Lord, the annual income has been fixed for the injuries sustained by the minors and the
Mallikarjun's
students.
case, view the judgment.
Mallikarjun case is also there. This is also, my lord, in
No, that is in the facts of the case. We'll look at Mallikarjun's case, that what needs to be applied.
please.
Take that.
Yes. Idi antale. Good.
So far as Mallikarjun case is concerned, my lord, if it is a,
And all those judgments, Master Ayush case
Yes, ma'am.
and other cases are extreme cases.
Correct, correct.
Which cannot be applied to a case where there is 3% disability.
I'm not saying, my lord,
So we will see whether Mallikarjun's case applies. If applies, what should be the,
up to 10%, my lord,
come to para 12.
one page is missing, my lord. In my judgment, my lord, one page is missing, sorry, my lord.
If they don't, Mallikarjun's case do not consider any disability below 10.
Yes, ma'am, it has been considered. If you up to 10%,
Above 10.
no, up to 10%,
Let me read it.
please, ma'am, above 10 to 30.
We are of the view that
Yes, ma'am.
appropriate compensation, in addition to the actual expenditure for treatment, should be if the disability is above 10% and up to 30%
Yes,
to the whole body, rupees 3 lakhs.
Yes.
Up to 60%, 4 lakhs, 90%, 5 lakhs, and above 90%. They have not dealt with a situation where the disability is below,
Yeah, up to 10%, not 1 lakh.
not up
Below-
to,
below 10.
above 10.
Below 10%, not 1 lakh.
Where do you get that?
That is the Lord.
Look at it, take this,
Sorry.
just give it to him. Give that judgment to me. Take that. Please read.
Mhm. We are of the view that the appropriate compensation.
You're reading which para?
Para 12, my lord. Para 12.
Read.
Though
That
it is
para
difficult.
12 says, though it is difficult to.
Yes, ma'am. Though it is difficult to have an accurate assessment of the compensation in the case of children suffering disability on account of a motor vehicle accident, having regard to the relevant factor, precedent, and the approach of various high courts, we are of the view that the appropriate compensation on all other heads, in addition to the actual expenditure for treatment attendant, should be if the disability is above 10% and up to 30% to the whole body, 3 lakh, up to 60%, 4 lakh, up to 90%, 5 lakh, and above 90%, if it is to be 6 lakh. For permanent disability up to 10%, it should be 1 lakh.
For permanent disability, up to, it should be 1 lakh.
Yes.
So in this, there are no other heads. It is, first is pain, suffering, everything comes, it is.
But my recent judgment of coordinate, my lord, that has been held, my lord. Kindly come to me, lord. Just I will pursue this honorable court, my lord, in paragraph page 26, my lord. Page 26 of the judgment, where, my lord, considering the, my lord, the amendment made in the year 1994, the annual income of rupees 40,000, it has been considered, and a year of inflation is taken into consideration, and the annual income
That's
has been
not
fixed.
the disability
And
of
also awarded, my lord, pecuniary
3%.
and non-pecuniary.
Huh?
The compensation is awarded towards pecuniary and non-pecuniary damages. Next page, it is, this is,
Please come to the facts of the case,
Yes,
which made the court to do all this exercise.
yes, my lord. In this case
Please,
also, my lord,
look at that. Please come to that. This is a case of death act.
no, it's a case of injury. My lord. All the
Let us
cases,
read, let us read.
all the
In a
cases, my
batch
lord.
of appeals disposed of by a separate order.
Yes, my lord. Kindly, my lord, in MFA number 7008 bar 2021, in that case, my lord, he was aged about 3 years. He was met with an accident and suffered injury to an extent of 15%.
Where, yes,
Yes, my lord.
3% and 15%, you cannot compare.
No. In that case, my lord, 15% is awarded to the upper limb only, but the trial court has taken into consideration 10%. Same has been retained. In page number 35, my lord. 35 of the judgment. MFA 7008 of 2021. Yes, my lord. Syed Kasi, the claimant in MFA number so and so, was aged about 3 years old when he suffered the accident, as a result of which he has suffered the subtendinitic fracture in his left femur. The doctor has assessed the disability at 14%, and on the basis the tribunal has
So
assessed.
where will this Mallikarjun judgment will go?
Yes, it has been discussed. My lord.
Hmm.
Same has been, it has been distinguished. My lord. Kindly come to, my lord. All the judgment has been discussed. Para 25, my lord. Para 25 of the judgment. From para 17, it reads, my lord. From para 17, Master Mallikarjun case has been taken into consideration. It is observed in para 17, and thereafter, my lord, para 22 onwards, it is to be noted that here that only in Master Mallikarjun case, as Apex Court held, that the amounts can be awarded for a minor's disability only towards for non-pecuniary loss. While the
The
subsequent decisions,
subsequent judgments of the apex court, like we have to look at the facts of the case also. Ayush and Kajal's case is, what are the facts of that case? And this is a case where 3% disability.
3% if it is taken,
You can't compare Master Ayush and Kajal's case to this.
I leave it to.
Which year is the accident?
2012 only. 23, 2012. He was inpatient for a period of 5 days.
Any medical expenses?
Yes, my lord, 19,000. 9,500. It has been awarded.
Para 9, my lord, last para. Medical bills amounted to rupees 9432 and it was rounded up to 9,500.
Any future medical expenses?
No, nothing is said about by the doctor, my lord.
One lakh 23,500. Agreed with the order passed in MBC number 369 of 2012 dated 22nd April 2013. The claimant is before this court seeking enhancement of the compensation. The court had granted the compensation as per the table given below, that is there in the synopsis. When counsel appearing for the claimant submits that in the light of the law laid down by the apex court and which was discussed by this, which was later considered and elaborately discussed by this court in case of Master Kartik and Nation Insurance Company Limited, arising out of MFA number 426 4124 of 2020 and MFA 7008 of 2021 dated 27th September 2024. This court has even considered pecuniary and non-pecuniary damages. It is submitted that the claimant, or the boy was aged about
2 years.
3 years.
3 years at the time of accident, and he had suffered a disability of 10% to the whole body. As such, the court ought to have granted the compensation ex per. When counsel appearing for the insurance company submits that the judgment in the above referred MFAs do not apply to the facts of the case, it is submitted that here the disability to the boy is 3%, and at best the Master Mallikarjun's case will apply where the disability where it is considered that up to 10% their entire what is the entitlement if the disability is up to 10%. It is submitted that the claimant is not entitled for the benefit or the compensation as per the law laid down in the above referred judgments. Next para. Having heard the learned counsel for the so this court has perused a judgment that is placed before the court, and where the court had considered Master Ayush and Master what is the other judgment? Ayush and Kajal and Master Ayush and Kajal's case. And coming to the facts of the case, this is This limb disability is 10% and to the whole body it is 3%. In those cases, this court is not inclined to apply the law laid down in the Kajal or Ayush case, or the judgment relied on by the learned counsel by a coordinate bench of this court. In the facts and circumstances, considering the injuries, the law laid down by the apex court in Mallikarjun's case squarely applied to the facts of the case, and as it is held, up to 10% disability under the head of pain and suffering, they are entitled for 1 lakh. And the remaining heads, with regard to the discomfort, inconvenience, and loss of earning to the parents, this court is granting an amount of rupees 14,000, and for medical expenses 9,500. Legal expenses in the light of the law laid down in so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 1,33,500. Accordingly, the appeal is allowed, enhancing the compensation from so and so to so and so.
Serial
This
number
next
2, Sandeepa SH for appellant, Ashok N. Patil.
injury or death?
Injury.
Hmm.
And the date of accident is,
What is the compensation granted?
it is 1,18,000. 1,18,800.
18,000.
1,18,800.
Disability?
Disability is taken at 12% to the whole body,
According to the doctor.
26% to the limb, and 12% to the whole body. There is one
And
fracture.
which year is the accident?
It is 2010 minutes.
How much is the income taken?
4,000 is taken minutes, 5,500 minutes as per the
2010.
2010.
5,500.
file. Yes.
Where is the table?
But it is at page number 12 minutes of the judgment.
Pain and agony. Only one fracture?
Yes, minutes, one fracture.
1,000. Medical expenses. 30,000. What is this loss of, what is a loss of future earning capacity? That is only 28,200,
Minutes,
800.
because
I think there is something wrong with the calculation.
the multiplier applied is at 5,
What is the age?
65 years. 7 should be applied.
Multiplier is?
7.
Hmm. So future loss of earning. If you take 5,500 into 12 into multiplier is
7 will come.
into 12 by 100.
55,440 will come.
55,000. 55,000.
440.
Like loss of income during later period. $16,500.
Yes.
Then, according to the doctor, what are the future medical expenses?
It was 20,000.
We'll grant 20,000.
That is.
What is this for unhappy?
That is
loss of
amenities. Amenities.
Another 10,000.
Please.
It comes to 1,91,940.
Yes.
Please come. The present petition is filed.
Delay.
Taking the agreed with the orders passed in embassy number 1862 of 2011 dated 29 July 2012. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed. Seeking compensation of an amount of rupees 10 lakhs, and the tribunal had granted the compensation as per the table given below at page number, para number 13, extracted. There is no representation on behalf of the claimant. This is an appeal of 2013. Hence, this court is inclined to proceed with the matter basing on the merits of basing on the material on record. The land counsel appearing for the respondent claimant submits that the compensation that is awarded by the tribunal is just and reasonable, and there are no grounds to interfere with the order passed by the tribunal. Next paragraph. Having heard the counsel for the petitioner, the respondent perused the entire material on record. The claimant has sustained one fracture injury and at the head of pain and suffering is entitled for an amount of rupees 40,000 as far as the medical expenses are concerned, basing on the evidence on record, court had rightly granted. Coming to the future loss of income, this court has observed that the income was taken at
4,000.
4,000. This is an accident of 2010, as per the table. As per the legal services table, the legal service authority, this court is taking 5,500 as the income, and the multiplier that is adopted is 5 instead of 7. Hence, 5,500 into 12 into 7 into 12 by 100 is 55,440. Then coming to the loss of income during the later period, considering the income at 5,500 for 3 months, 16,500. Future medical expenses, as per the evidence of the doctor, it is stated that it is 20,000, quoted granted 10,000, and this court is enhancing it to 20,000. Loss of immunity is also quoted granted 10,000, and this court is granting 20,000 considering the disability. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, claimant is entitled for 1,91,940. Accordingly, appeal is partly allowed, enhancing the compensation from 1,18,800 to 1,91,940. As per the order dated 29/6/2016, the claimant is not entitled for interest for a period of 298 days. Next.
Cell number 3. Sadashivaya KG for appellant.
No.
It's not come today. I appear for the respondent. Sadashiv has not come.
Yes, you can argue. What is
We passed over the time.
pass? Next.
Cell number 4. YP
Lord,
Venkatapati.
I am for respondent claimant, my lord.
Appellate.
Yes.
My lord, I am for respondent.
Company's appeal challenging the phantom alone.
Let's go to that. It's a case of injury or death.
Submission, madam.
It's a case of injury or death.
Injury, my lord. Case of injury.
Case of injury.
Where is the table?
No table is forthcoming, my lord. Quantification found in para number.
What are the injuries? What are the injuries?
Fracture of both the bones of.
My lord, may I make submission, my lord?
Yes.
In this matter, he claims that he has suffered a fracture of both bones. But as per medical records, only tibia is treated, not both bones. And the next is, apart from the injury is not an issue, and other things are not an issue. Issue is only in respect of the compensation awarded in respect of later period and the special allowance that has been awarded by the tribunal. And medical expenses, according to PW3, who is examined to prove the employment and income, he says unless the railways grant permission, he cannot take outside treatment. But after taking treatment, he can submit his bills to the office and he can get reimbursement. These are the facts about that. And now, my humble submission is loss of earnings during later period 4,71,468.
No. Pain and suffering, no issue on that.
No issue.
Madam?
You will not have an issue. He will have.
In this matter, problem is the tribunal has not considered the evidence which is available on record. That is,
I'm asking you, now we'll go head by head. So pain and suffering is anything to be, do you have
no, we
anything
have
to
no issues about all those things. We have issue only in respect of loss of income during later period and special
One
allowance
minute, one
awarded.
minute, 1 minute. What about future medical expenses?
Future medical expenses 30,000 awarded, it is not challenged.
No, please come to the discussion with regard to loss of earning.
Yes, my lord. In this matter, directly we can go to exhibit P11, my lord.
Discussion.
No, before that, we will read the finding of the court.
Finding, my lord, tribunal only when you go to exhibit P11, we can understand tribunal has not adverted the facts available on record.
Let us read issue number 2.
Page number 9, bottom, it starts from page number 9, bottom. Page number 10, also bottom, as per the evidence of PW3. My lord permits, my lord,
Yes.
my lord, what happened is earlier at the time of accident, he is working as a driver, that is a loco pilot at railway. My lord, after accident, even though salary is not decreased, but his position is changed.
Please wait for your turn.
Now I get the permission of the court.
Just wait. No, at internal page 11.
Yes, please.
Please come to read the bottom 4 lines. But
on account of accident injuries, he is not in a position to continue as loco pilot, and thereby there is loss of kilometrage allowance. According to me, the petitioner is entitled for special allowance of 3,42,500. Exactly, that is what I am challenging, my lord.
On what basis the court has come to this figure?
This court has come to conclusion based on the oral evidence of PW3, where he says probably he is losing. Your lordships will find 1, 2, 3, 4, 5, 6, 7, 8th, 9th line, 8 to 9, in the same
Page
page.
number 11 of the judgment.
However, page number 11. However, it is deposed by PWT that
No.
the petitioner was earning a sum of
No, no.
2,000 per
Whom
day
the,
as a local pilot kilometer.
whom the claimant has
This,
examined, that because of this injuries, there is an impact on his work, and he has been any demotion, or he has been given less salary.
it is not there.
Yes,
PW3,
Mr. Shastri.
PW3 explained. My lord,
Who is he?
is the employer. PW3 is the employer. My lord, in his evidence, he appointed that that after the accident, he deposed that after the accident, he lost the opportunity to serve in railway as a loco pilot, and he has a different job is given to him. In being a loco pilot, my lord, he was earning 2,500 regularly per day. My lord, as a loco pilot, that is appreciated by the trial court, and for at the rate of
No. Apart from your salary of 78,576, you will be getting 2,500 every day.
every day as a loco pilot allowances, that is now lost. That is, but future loss of earning is not awarded. As the same way, loss of amenity is also not
No,
awarded.
let
But court quantified it at the rate of this 2,500 per day. Well, 3,42,000. That it about
Any appeal is not there. Yes, Mr. Counsel for the Insurance Company. Now, please come to the evidence of PW3. What did he say?
My lord, for that only it is required to be seen Exhibit P11, because Exhibit P11 creates what is the basis for awarding loco pilot allowance, because your lordship
Yes.
see the kilometer allowance 11,475 mentioned in the salary slip, that is at Exhibit P11. If we divide it to 30 days, we will get about 370 rupees, 116 paisa per day. Not 2,500. What was his loco pilot daily allowance?
KMA 11,475.
475.
That is 300 and
Kilometer allowance. 370.16 it may come. That is per day allowance. Whereas tribunal has taken oral evidence of 2,500 per day. It is against law and against documentary evidence.
yes. What do you say, Mr. Shastri, on this
for
exhibit P11?
for 120 kilometers where he has to drive. For that, my lord, 2,500 is the allowance.
No, we have
That is
to
correct.
look at,
That is correct. Tribunal
no,
has
no, we have to look at your salary slip to know
Yes.
that. Exhibit P11, what it says? P11 says KMA is 11,475. Then how we have to consider it as 2,000 per day, 2,500? Now, if 2,500 every day you work, you'll be getting more than your salary, your allowances.
If your claim
PW
were to be true, my lord, he claims salary as 60,000 rupees per month in the petition, whereas tribunal has taken 78,576 without any basis. When we deduct this arrears out of this salary slip, the actual salary that would come to 46,558 monthly salary.
Hmm. Because from 78,576, this has to be deducted 11,475.
Well, arrears basic pay 10,160, arrears DA 4,568, and arrears of HRA 3,964 that has been paid in the salary slip. And when we eliminate these things, his salary will come to only 46,558.
My lord, for 6 months, my lord, since he is not draw any salary, my lord, loss of earning for 6 months is awarded at the rate of 78,578. If it is my lord is found to be wrong, my lord, that should be deducted. That is
Yes.
the reason assigned by the trial court.
Yes.
Special leave allowances, my lord, 3,42,500, my lord, is entitled. That has been awarded. Apart from these 4,71,468, that is for 6 months. My lord, loss of
That
amenities
is also again wrong manner, because PW3 says he was authorized for duty only for 113 days, but whereas tribunal has taken 137 days.
So as per your calculation, how much it has to be?
In all, in my assessment, my lord, 4,91,000 is in excess.
And was loss of earnings during the later period. So according to his salary is 46,558.
No, it
Yes,
is,
my
it
lord.
is Malad, apart from this 46,000, Malad is entitled for other the regular allowances. Regular
That
allowances.
allowances, no, if you are on leave, you will not get HRA.
He is working
For
still
6
now.
months,
Also, he is working.
for 6 months, HRA is no question of deducting HR and other allowances, Malad. Suppose if he works for 6 months, Malad, he is entitled in the rate of 78,578, and I think my learned friend has no such issue on that point. Only is concentrated on this 3,42,000.
No, even for 4,71,468 also, he is saying that the salary is 46,000 because
No,
when you are having it,
558.
again, you cannot have this 11,000 there and here also.
yes,
No, loss of special allowance is calculated on that amount. You can't have that amount in loss of earning and again loss
as
of
well as
allowance.
no.
Both
Yes,
you cannot have.
exactly.
Malad, if it is considered as a double payment, Malad, kindly, my lord,
No,
may
we will
kindly
see. We will see. Now, what we do is we will deduct from 78,
78,000.
78,000, 1 minute,
Your Lordship will, your Lordship
78,576.
will also see other exhibits annexed to that. Rate of pay for him is 22,730. Constantly, that is the pay that has been shown in other salary slips.
I'm not able to understand. What is that? What is that?
In the other salary slips, which he has
Uh,
produced for other months,
uh.
22,730 constantly shown as salary, rate of pay.
Where is that exhibit? Which is the exhibit? Same.
And that is column number 1, 2, 3, 4, 5, fifth column. But in spite of that, even if it is not taken, if some allowance is added, it may come to 46,558. We don't know what is the basis for that.
Malad,
It comes
they,
to, it comes
Malad,
to, it is
Malad,
so difficult for the court to deal with both of you online with this kind of contested matters. Please come to the court. List this matter next week. Give a date.
Next week, my lord. Oh.
date
9/4.
8, madam? 8 or
9.
9, my
9,
lord?
994.
Much.
Parted matter, cell number 5. Gopal Krishna Gowda for
Here for the
petitioner.
petitioner, my lord.
You're seeking for a transfer from where to where?
From Chitradurga to, one second. From Chikmagalur to Chitradurga, my lords.
Distance?
130 kilometers, 4 hours we need to travel, my lord. She has a minor child, my lord, with eyesight
Age
issues.
about?
38 years, my lord. Son is 10 years, my lord. And unfortunately, the
Present
respondent
petition
is
is
money
seeking
lender, my
transfer
lord.
of order sheet also give. order sheet seeking transfer of MC number 88 of 2024 pending on the file of the Senior Civil Judge JMFC Court, Kadur, Chikmagalur District to the Principal Senior Civil Judge and JMFC Court at Chitradurga. The facts of the case are the marriage has taken place on 8/3/2015 at Bhimasamudra, Chitradurga Taluk. And in the wedlock, they're blessed with a male child on 30/12/2015. On 27/8/2021, the wife had filed a petition, filed a complaint under the Domestic Violence Act on the file of, that is, Criminal Miscellaneous 383 of 2021 before the Second Additional Civil Judge and JMFC Court at Chitradurga. On 23/10/2024, Hassan filed the MC before the Senior Civil Judge and JMFC Court, Kadu, Chikmagalur District. And she filed MC number 173 of 2024, seeking restitution of conjugal rights before the Principal Senior Civil Judge and CJM Court at Chitradurga on 7/11/2024. It is submitted with the land counsel for the petitioner that the distance between both the places is 130 kilometers, and she has to take care of a boy who is aged 10 years. It is submitted that that it would be difficult for her to attend the courts at Chikmagalur. Notice is next para. Notice what T, why this T Girish name is coming. This court, as per the orders passed by this court, take the docket order. As per the orders passed by this court, the notice is taken, the petitioner has taken out notice on the counsel, appearing for the respondent before the trial court and filed a memo to that effect. And this court has also directed the name of the advocate to be printed in the cause list. Hence, notice to the respondent is held sufficient. Next para, considering the reasons, considering the submission of the counsel and considering the fact that already a complaint under the Domestic Violence Act and a petition for restitution of conjugal rights is pending at Chitradurga, and the wife is staying at Chitradurga and taking care of a boy aged 10 years, this court deems it appropriate to allow this petition accordingly, and wife shall cooperate. Next.
Cell number 6, N. Krishnaswamy for appellant, Pundika Ishwara Bhatt.
Senior has some personal inconvenience today, my lord. 2 days time, my lord.
This is matter on 15th. No further adjournments at the request of then counsel appearing for the claimant. Next.
Cell number 7, T. Mohandas Shetty.
Not there on the last occasion also?
The claimant counsel remained absent on the last date of hearing, taken as part heard.
Yes, we'll hear it.
That 5 claim petitions. All the cases are injuries.
Dismissed or allowed?
The 2 vehicles are involved, Tempo Traveler and Maruti van. I am for the insurer of the Tempo Traveler. The negligence is fixed on the driver of the Maruti van.
No, let's see. This MFA 6313 arises out of?
60?
First one, 6313.
6315 arises out of MEC number 2464 of 2010.
2464. Then next.
6317.
14.
6314 is 2466 of 10.
6315.
6315 is 2464, my lord.
6317.
2465. And 6313 is 2463.
So first let's go to this 246 MBC 2464.
2464. She is aged around 50 years. And the amount of compensation claimed is 3 lakhs.
Granted is,
Please, my lord.
how much is granted?
Granted is 9,000.
Year of accident is 2013.
2010, my lord.
10.
25/3.
Which page is that? Discussion with regard to MBC 464.
Let it is not be dismissed. The claim petition is allowed against the owner of
I
the
said discussion. Discussion.
discussion regarding negligence is at para number 12 and page number 9 of the judgment.
Please read.
Since all the claim petitions are arising out of the same accident, the issue number 1 in all the petition in regard to the negligence, they are taken up together for the discussion in order to avoid the repetition. Since the claim petitions are filed under section 166 of the Motor Vehicles Act 1988, it is incumbent upon the petitioners to prove the negligence on the part of the tempo traveler bearing number so and so in occurrence of the accident. On the other hand, respond number 1 and 2, having taken as plea that the accident occurred on account of the rash and negligent driving of the Maruti van bearing number so and so by its driver, they require to prove the same by placing record cogent and convincing evidence. All the petitioners have stated in the petition that the accident occurred on account of the rash and negligent driving of the tempo traveler bearing number so and so by its driver. Apart from the case made out by them in their petitions, all the petitioners who have been examined as PW 1 to 5 reiterated the negligence attributed to the driver of the tempo traveler.
All of them were traveling in a Maruti.
They were all in the occupants of the Maruti van. Let your lordship may kindly see the next sentence in the same paragraph. Further, the petitioners have also produced Exhibit P1 FIR registered against the driver.
I just wanted to know how the accident has happened.
The Maruti van driver came to the extreme right side of the road and dashed against the tempo traveler.
You have insured tempo traveler.
I am the insurer of tempo traveler.
Maruti Omni. Now the case is
Maruti Omni is insured with Bajaj.
No.
I'm sorry.
No. According to them, the negligence is on the Omni, the tempo traveler.
Tempo traveler.
They have not stated about any negligence of the.
No, but the crime is registered against the driver of the Maruti van. Charge sheet is filed against the driver of the Maruti van. That is the reason why the court gives a finding and dismisses the petition on the count of negligence against the insurer and owner of the tempo traveler. I'll read the next paragraph. The second respondent has examined one where K. Venkatakrishnan working as an assistant manager in their office as RW2. In his evidence, he has reiterated the averments of the objection statement to the effect that as per the crime records, the accident took place due to the negligence on the part of the driver of the Maruti van bearing number so and so. And hence the jurisdictional police, after investigation, have filed the charge sheet against the driver of the Maruti Omni. As against the evidence of RW2 who attributed negligence on the part of the driver of the Maruti van, in occurrence of the accident, the respondent number 3 has got himself examined as RW3, wherein he has made an effort to counter the evidence of RW2 by attributing the negligence to the driver of the tempo traveler bearing number so and so in the occurrence of the accident. In this background, in the background of such a contention taken on behalf of the respondent number 2 and 3, if we go through the contents of the police document, it becomes abundantly clear that as against the case being tried to be made out by the petitioners in their petition as well as in their evidence as stated above, the complaint FIR as per Exhibit P1 filed against the petitioner number MVC number 2463 of 2010 is the driver of the Maruti van, who was the driver of the Maruti Omni van driving in a rash and negligent manner and dashed against the tempo traveler. Further, if we go through the contents of Exhibit P2 spot panchanama and Exhibit P3 spot catch, it becomes further clear that the tempo traveler was coming in the correct side of the road. It is the Maruti van driven by petitioner in so and so went to the wrong side of the road and dashed against the tempo traveler. Added to that, in the cross-examination of PW1, the driver of the Maruti van has admitted in clear terms that the road where the accident occurred is a straight road, and therefore the vehicles coming from the opposite at the time of the accident, tempo traveler was coming from the PW3 so and so. In their cross-examination, have categorically admitted in the sketch drawn by the police, the car shown to have went to the wrong side of the road and dashed against the tempo, and the sketch has been correctly drawn by the police. And and that it is true that the police, after investigation, have filed the charge sheet against the driver of the car. It appears that it is for this reason the petitioner MEC number 2463 of 2010 has not filed the copy of the charge sheet filed against him by the police after investigation. Under such circumstances, though the petitioner contended that the tempo traveler which came from the opposite direction and dashed against the car in which they were traveling and caused the accident, but the documentary evidence coupled with their admission in the cross-examination tells a different story, in as much as it is the Maruti Omni driven by petitioner so and so, which went to the wrong side of the road and dashed against the tempo traveler. Under such circumstances, I am of the opinion that the accident occurred due to the negligent driving of the Maruti car by the petitioner in MEC 2463 of 2010, and the accident in the accident the petitioner so and so have sustained injuries. Accordingly, the issue is answered in negative and issue number 1 answered in affirmative.
What do you say on compensation of 9,000?
Transport vehicle. Please, Malak.
Compensation of 9,000, what do you say?
I have nothing to say because all the claim petitions are dismissed against the insurer of the tempo traveler.
No, generally, otherwise.
Malak, 3, there are claimants. Claimants.
We are on now 2464.
2464.
9,000 is awarded.
Yes. Yes,
3 simple injuries.
3 simple injuries.
No evidence is adduced.
Doctor is not examined in all the cases.
Produce exhibit 317, 4 bills for ₹500.
Swelling, tenderness over the root of nose. Swelling and tenderness over the left forearm, including wrist. 4 into 3 centimeter cut lacerated wound over the knee joint. Another 6 to 8, another 10,000 rupees globally, madam.
The global compensation. Compensation of 20,000. What about the owner? Is he there before the court? No, the appeals are by the owner or the
claimant.
Owner is served. Who appeals for the owner?
Claimant. 2463 is by claimant. Hombaram. Claimant. 2467 is by claimant.
Served. R3 served.
Claimant is
R1, all are served. Owner is served.
Served.
But not representing. Next matter.
Next matter is. $2465. 12,500 is awarded. Here also 3 injuries. 4 into 2 centimeter cut lacerated wound over the, Lordship find it at page number 15 of the judgment. Cut lacerated wound over the forehead, bleeding on top, tenderness over the chest, contusion over the right side of the face, and bleeding. Doctor who has issued exhibit P7 wound certificate has opined that the injuries are simple in nature.
12,500 is granted in this.
Maybe rounded up to 20,000. Rounded up to 20,000.
What is the claimed compensation in MBC?
2465, 3 lakhs.
In all cases, 3 lakhs.
No. This
case also you said 3 lakhs.
Same. 2464, 3 lakhs. 2465, 3 lakhs. 2466 is 5 lakhs.
2466 is
5 lakhs. 2467 is 2 lakhs.
How much is grant?
2467
is 5 lakhs.
2 lakhs.
2 lakhs.
8,000 is granted.
In which case?
In this case, 2465 is 12,500.
12,500. 2466?
2,000?
2466.
2466 is 1,95,000.
Is granted?
Yes. The claim is 5 lakhs.
25,000. Where is that? MBC 2466. Now let's see what is the calculation. The right arm, swelling and tenderness for the right.
That your lordship will find at page number 21 of the judgment. Page number 21 of the judgment. The injuries are swelling and tenderness over the right arm, swelling and tenderness over the right elbow joint. It's a fracture of humerus.
One fracture. 2466.
Injury, pain and suffering 30,000. Medical expenses 99,021. Attendance charges 6,000. Conveyance charges 6,000. Loss of income during treatment 8,000. Loss of earning
How many
capacity.
days he was in hospital as per the discussion? Please look at it.
3 days. From 11/10/2009 to 14/10/2009.
Attendance 6,000, conveyance 3,000, reasonably granted. Loss of income during the treatment.
The doctor is examined as PW6. The lordship will find it at para number 28 and page number 19 of the judgment.
How much is the disability according to him?
12% to whole body, 20% to the limb, and 12% to the whole
What
body.
is that? How much?
20% to the limb,
20% to the limb.
12% to whole body.
Court had taken?
Court has considered that 5%.
Income was taken?
Income is 2004. No. 4,000 per month.
4,000. Which year is the accident?
2009.
It should be 5,000. So 15,000 loss of income. Loss of future income.
12% disability.
What is the multiplier?
Multiplier is 16 million.
5% is a disability.
5%. It should be 7%. Even if it is taken as
One third,
it comes to around 6 point change. 7% may be considered.
$67,200. Future medical expenses. What did the doctor say?
He has not said anything about them. 20,000 rupees.
We will grant 20,000. Loss of immunity not granted.
No, Malay. Future medical. ಅದನ್ನು 20 ಮಾಡ್ತಾರೆ. 20 ಮಾಡ್ತಾರೆ.
It comes to 2,75,221. What about the next case?
Next case is 2467.
Hmm.
3 simple injuries. 8,000 is granted. 2467. Page number 21. Madam.
How much is claimed? For 2 lakhs.
2
Granted
lakhs.
is
8,000. Tenderness over the right forearm, tenderness over the chest, tenderness over the left knee joint.
this also will make a global compensation of 20,000. Please come.
As far as liability is concerned, I may have to pay the compensation.
You may have to.
I may have to pay the compensation.
Yes.
In view of Mukund Dev.
No, but no, not that. That's why I was asking the facts. Their case is that because of the negligence on the part of the tempo traveler, the accident has happened. That is their case, is it not?
That is the case of the petitioner.
Claimants. Then in that case, how are you liable to pay?
He is the insurer of the Maruti van, against whom the court finds fault with them.
Compensation is awarded.
No, it is correct. That is nobody's case. They have not claimed compensation against you.
Yes, they have claimed both the
The
vehicle.
composite negligence.
Yes.
Or not a case that it's only because of.
No. The owner and the insurer of the
So
Maruti
that's what I was
van.
asking you first also. What is the case of the claimants? I was under the impression, according to the claimants, the accident had happened because of the negligence on the part of your tempo traveler. And court gave a finding stating that that's not the. Come to the liability issue. Where is it?
The liability. At para number 31, Malad. Page number 22.
Let's read.
The respond number 4, insurer admitted that insurer is the insurer of the Maruti van, admitted having issued an insurance policy in respect of Maruti van bearing number so and so. However, it is contended that the said vehicle is a luxury taxi which falls under the category of a commercial transport vehicle, whereas at the time of the accident, Rajashekar Ayya, who was driving the said vehicle, had a license to drive LMV NT only. In other words, he had no license to drive the Maruti only in question, which is.
So this is the ground how the insurance company is exonerated.
Owner is made liable.
Now the liability has to be.
Please come.
First petition dismiss IO.
But claimants
tempo traveler agreed with a common order passed in MBC number 2464 of 2000, 2464, 2466, 246. I think 2 times the numbers have come.
2463 is 6313 of 2013, my lord. The claim petition is dismissed. 2463.
No, in that case, the court said he is not entitled for any compensation.
That is dismissed. That was the claim petition made by the driver.
Because he is held to be responsible for the accident.
Yes, his claim petition is
So
dismissed.
I think the facts needs to be changed. No, in which case this 2464 is then from the next.
My lord, I repeat the numbers. The MFA 6315 of 23 is MEC 2464 of 10.
No. MFA 6314 is?
63
No, I'm looking at how it is listed in the cause list.
Yes, ma'am.
6314 is?
24?
MFA 6314.
What is the first MFA number, my lord?
First MFA number is 6311. Oh, another one is there, 6316.
6316 is 2467 of 10.
2467
of 10.
6313?
6313. 6313 is 2463 of 10. That is by the driver of the Maruti van.
Next. 6314?
6314 2466.
6315?
2464.
6317 is 2465.
2465.
Agreed with orders passed in MBC number 2467, 2463, 2466, 2464, 2465 of 2010. Claimants have filed MFA 6316, 6313, 6314, 6315, and 6317 of 2013. The trial court by a common order had disposed of all these appeals, as this court is also disposing of all these appeals by way of a common order. The facts of the case are the claimant in MVC number 2463 of 2010 was the driver of the Maruti Omni car, and other claimants are traveling in the said car. It is their case that when the vehicle reached near Belloor Cross at about 1:50 p.m., a tempo traveler came from the opposite direction in a rash and negligent manner, that too on the extreme right side of the road, and dashed against the Maruti Omni, and all the claimants have sustained injuries. The tribunal has held that there is no negligence on the part of the driver of the tempo traveler, and the police records reveal that the case is registered against the claimant in MBC number 2463 of 2010, who is the driver of the Omni van. Hence, the court has held that there is no negligence on the part of the driver of the tempo traveler, and the negligence is on the part of the claimant in MBC number 2463, who is the driver. When it comes to the liability, the court has held that the driver is not having a license to drive a LMV non-transport, but he is driving he's having a license to drive a LMV non-transport, but he is driving a transport vehicle. As such, insurance company is not liable, and it's a owner of the vehicle who is liable to pay the compensation. When it comes to the compensation, the court had awarded compensation of an amount of rupees as per the table given below. Make a chart. In MVC number 2464, an amount of rupees 9,000 is granted. 2465, 12,500. 2466, 1,95,000. 2467, 8,000 is granted. And claimed compensations are in MVC 2464, 3 lakh. MVC 2465, 3 lakhs. 2466, 5 lakh. 2467, 2 lakhs. And in 2463, how much was claimed? Just look at it and tell. 2460 so and so is then. All these appeals are filed.
10 lakhs.
Huh?
10 lakhs.
10 lakhs. The respondents, you appear for?
The second respondent.
The second respondent in this appeal, the second respondent insurance company had insured the tempo traveler, and the fourth respondent insurance company had insured the Omni car, Omni van. This matter came up on 26/3/2025. As there was no representation on behalf of the appellant, this court had listed these matters under the caption part heard. Even today also, there is no representation. These are all the appeals filed in the year 2013 seeking enhancement of the compensation. Even after 12 years also, as the appellant is not, the counsel for the appellant is not appearing before the court. The court is inclined to dispose of these matters basing on the material available on record. The counsel appearing for the respondent insurance company, which has insured the tempo traveler, submits that the court had rightly exonerated the insurance company and considering the oral and the documentary evidence placed before the court. Land counsel appearing for the insurance company which had insured the Omni van, submits that the court had rightly held that the the owner is liable as the driver is not having a valid driving license to drive a non-transport LMB non-transport, and there are no reasons to interfere with. This court, having heard the land counsels appearing with the respondent insurance company, had perused the material on record. Coming to the MVC number 24, so the MVC number 2460, that is MFA number 6313, the caption. And coming to this, the claim petition is filed under section 166 of the Motor Vehicles Act. The evidence on record clearly discloses that because of the negligence on the part of the driver, that is the claimant in MVC 2460 of 2010, the accident had taken place. This court had perused the finding of the tribunal where it is stated that a person who is responsible for the accident cannot claim claim the compensation. In the considered opinion of this court, the said finding of the court requires no interference. Accordingly, MFA number 6313 is dismissed. Next, coming to MVC number 2464 of 2010, that is MFA 6313 of 2013. The clear compensation was claimed as 3 lakhs and the court had awarded 9,000. In these cases, except placing the wound certificate and the bills, the bills, the claimants have not introduced any other evidence. They have not introduced any other evidence, and the court had granted 9,000 as compensation. Considering the injuries, this court deems it appropriate to award a global compensation of an amount of rupees 20,000. Then coming to MVC number 2465. Arising out of MFA number 6317 of 2013. In this case, 3 lakh compensation was claimed and the court had granted 12,500. Even in this case also, no other doctor was examined and no other evidence is adduced. Hence, in this case also, the court is considering the injuries, court is granting for global compensation of 20,000. Then coming to MVC number 2466, arising on MFA number 6314, arising out of MVC number 2466 of 2010. The claimant had sustained one fracture injury, hence under the head of pain and suffering, this court is granting 40,000. Towards medical expenses, court had rightly granted the compensation and there are no grounds to interfere. And even for attendance and conveyance also, but for 6 days or 3 days of hospitalization.
3 days.
3 days of hospitalization, court had granted 9,000 and no interference is called for. Coming to the loss of income during the later period, as this is accident of the year 2009, taking into 2000 accident of
2009.
2009. This court is taking the income at 5,000 and for 3 months granting 15,000. Then for loss of income during the later period, the court had according to the doctor, it is 20% disability to the limb. Hence, this court is taking 7% as a disability. And 5,000 into 12 into 16 into 7 by 100 is 67,200. Future medical evidence expenses as per the doctor, it is 10,000, but the court had granted 20,000, court had granted 10,000. Hence, this court is granting 20,000. Towards loss of amenities, no amount is granted. Considering the disability, this court is granting 15,000. In the light of the law laid so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 2,75,221. Accordingly, the appeal is partly allowed. Then coming to uh, 2467, MBC 2467, MFA 6316 arising out of 2467 of 2010. In this case, court had granted 8,000. Same like in other cases, global compensation of 20,000. Next, coming to the liability, the tribunal has fixed a liability on the owner of the Maruti Omni van on the ground that he is not having a license to drive a transport vehicle. In the light of the law laid down in Mukund Devagan says, insurance company is liable to pay the compensation. The compensation amount shall, the enhanced amount shall carry 6% interest. All are partly allowed. Yes.
Cell number 8.
For appellant in connected matter.
Patel D. Karegowda.
You are on what ground? What about
case, fall from motorcycle is converted as
Exhibit P7, discharge summary discloses history of accident is fall from bike. And Exhibit P4 is a wound certificate. It history of accident, alleged history of accident is RTA. It is written RTA. Kindly be seen, Exhibit P4.
Have you seen that?
Yes, RTA. In fact, it is written as RTA. Wrote
Exhibit P4 written as RTA. Insofar as the discharge summary, Exhibit P7, there is observation that fall from bike. There is observation. And, wound certificate is a preliminary document. Discharge summary will be put up in a later stage. Therefore, this document prevails over the discharge summary. And a charge sheet is filed against the offending driver of the offending vehicle. The respondent insurer not let any evidence before, not produce any document also. Police records clearly reveals that the accident occurred.
Yes, Mr. Krishna.
after a lapse of 5 days, a complaint is lodged. The case was that it was a road traffic accident. They give information to the hospital that he fell down from the motorcycle. Fall from motorcycle exhibit their own document would indicate the same. And to contradict this one, no other evidence is adduced by them. After lapse of 5 days, for convenience sake, they lodge a complaint against another motorcycle. So that
there is
exhibit P7.
Give the file first.
This was observed by Menard last time. Exhibit P7. Ukard Hospital discharge summary. Cause of accident is also revealed.
And brother-in-law was not examined. This is dated 13th September 2009.
Yes.
Exhibit P7. Then
Exhibit P4, madam. Own certificate. In fact, that is the preliminary document, madam. History of accident is RTA, is written.
and whether it is informed to the police,
Malad,
road traffic accident,
please, Malad. Malad, complaint was lodged. Malad, there is
not complaint. The police, if you are admitted in the hospital, there will be a entry in the MLC. Why you have not produced MLC extract?
MLC register not produced, madam.
Why?
And he
What
admits in
immediately
he admits in cross-examination PW1 that ಅಪಘಾತ ಆದ ತಕ್ಷಣ ನಿಟ್ಟೂರಿರುವ ನಮ್ಮ ಕ್ಲಿನಿಕ್ ನಲ್ಲಿ ಸ್ವಲ್ಪ ಚಿಕಿತ್ಸೆ ಪಡೆದೆ, ಅಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆದ ಬಗ್ಗೆ ದಾಖಲೆ ಪಡೆದಿಲ್ಲ, ನನಗೆ ಆದ ಗಾಯಗಳು ಸಾಧಾರಣ ಸ್ವರೂಪದ್ದು ಹಾಗೂ ಠಾಣೆ ಹಾಕಿಲ್ಲ ಎಂದು ಲಕ್ಷ ರು ಖರ್ಚಾಗಿದೆ, ಇನ್ನೂ ಖರ್ಚಾಗಿದೆ ಎಂದರೆ ಸರಿ ಹೇಳಿದ್ದೇನೆ. ವೈದ್ಯರ ಮುಂದೆ ನಾನು ಯಾವ ದ್ವಿಚಕ್ರ ವಾಹನದಿಂದ ಅಪಘಾತವಾಗಿದೆ ಎಂದು ಹೇಳಿದ್ದೇನೆ. How
It means?
That means before the doctor I have informed which two-wheeler involved in the accident, fall from the motorcycle. That is what he has revealed. He admits in the cross-examination.
Immediately after the accident, he was taken to a private clinic. It is evidence, before
a document is produced by you.
Please.
Whoever produces a document in support of that, you only have to adduce evidence. Somebody else will not adduce.
Please.
When there is a delay, and in one of
Delay,
the
there is
discharge summary, what happens is doctors, when they examine you, whatever they say, they will write down, and the same will be reflected in the case sheet and the discharge summary. It would be the same. So, if something, there are two contrary documents, nobody asked you to mark this discharge summary. You marked it. And the contents of it, you are only responsible either to prove or disprove it.
Please, madam. But exhibit P4, one certificate is preliminary document. That is what that could be considered, because discharge summary is simply there is one mentioning that fall from bike. Malad, who has given that information is not malad, it is not forthcoming. But
Then
simply because of that observation.
Then who has to do it? Whose responsibility is that? Who has written it, how it has been written? Then what you are supposed to do? You are supposed to do in the light of the delay of 5 days, and when they are disproving all these things,
Please.
and you should have examined the doctors that this is not a fall from bike, it's a road traffic accident. Why that? Why it is mentioned like that?
This contention is taken before this honorable court, Malad.
Which one?
This contention with the implication of a vehicle, the fall from bike. This contention is seriously taken before this honorable court.
That's not
Before
their case.
Before the trial court, the contention that there is no DL. Malad, that was the.
I'm sorry. In fact, in the cross-examination also, it is suggested that you have implicated this because there was no license to the, no policy to the motorcycle in which he was traveling. Otherwise, you would have claimed.
That suggestion was made, but in so far as Malad, whether he fall from accident occurred due to fall from bike or Malad, that was
No,
not
one more thing is, whatever you have put in the cross-examination, that's a different one. Now, there should be a pleading, isn't it?
My lord,
Saying that if unless and until there is a pleading, how would he take steps when you are accepting the accident and only saying that the driver is not having the valid driving license?
that was,
Let's see your written
my
statement.
lord,
What is your
that
plea?
is,
Added to that, my lord, added to that.
Let us see
One
the
minute,
pleadings.
1 minute.
Then we will go to your submission.
you have copy of it.
Extract, judgmental extract. Contentions, my lord, have been.
A written statement filed by the respondent. You have it?
My lord, a copy.
Give it to him.
My lord, rest. The owner's written statement is, that is the first one. He denies it is false to say that claimant was met with an accident and sustained injuries in the accident.
So please look at your statement.
That is the written
No, no.
statement of owner.
No, just look at it.
My written statement is, it is absolutely false to state that on 8/9/2009 at about 9 a.m., the claimant and his brother-in-law were proceeding on the extreme end of the left side of NH 206 from Nittur bus stand to their house with cautiously. When they reached in front of house of Muniyappa at Nittur, at the relevant point of time, a Hero Honda CD 100 bike bearing number so and so being driven by its driver in a rash and negligent manner with high speed without following the traffic rules came from backside on the claimant and dashed to him. On account of this accident, the claimant sustained
General
injuries.
denial.
Denied.
General denial.
The entire thing is denied.
That's
And
what I'm
then
saying.
once
General
again,
denial.
delay in, my lord, they also say delay in filing FIR. Hence, the petition be dismissed. This respondent does not admit the denies hospitalization expenses, etc. Everything is denied, and 134 is not complied even by the claimant also and by the owner. My lord, we refer to that he was not walking on the street and was hit by a motorcycle. That's I have denied.
That is what you have just read is every para repeat and deny.
Only
Not
one.
a specific denial it is. It's a general denial, making a general statement.
My lord,
What is happening in all these cases is, it's all budding out of the brain of the High Court advocate, all these grounds.
No,
Nothing
these
will
are
be
in
taken,
fact,
nothing will be
my lord,
taken before
my
the
lord,
court.
as far as trial court is concerned, on this line only the cross-examination is also made.
No. First of all, there should be a pleading.
Pleading
and
to the
pleading-
effect, my lord, he comes, I submit, he comes to the court with a pleading that while he was walking, he was hit by a motorcycle. My lord, his own documents would indicate something else. Those documents are produced before this court. And during the course of cross-examination, also he admits that he has stated how accident took place. And that document is also available on record. No other proof was required to substantiate that misrepresentation is committed by them. This is number one. Number two is, the person who comes to the court may have to prove his case as known to the law. My lord, he states that he was riding and his own documents, he fell down from a motorcycle. That is what
Because
documents.
one document is in his favor and the remaining
My lord,
documents,
no other
police documents are also supporting him.
My lord, he lodges a complaint after 5 days. And in fact, in most of the cases, what I observe is, for convenience sake, a complaint is lodged. Police, in connivence with the claimants, they will lodge a case against the person who supports them. That is what has happened. That 5 days delay is not explained. And also RTA is mentioned in wound certificate that is issued after 1.5 months from the date of occurrence of accident. 510.
After completion, I will. No, in the
That document can't be related.
In the complaint, there is a clear explanation for delay. In the complaint itself, there is a clear explanation for delays. Second point is, my lord, I have discharged my burden.
Lapses on your part is not filing the MLC register, extract of the MLC register.
That is,
And when there is two contradicting documents which are filed by you, then you have to substantiate your case or not, saying by examining somebody.
if would
You can't, when that's your document, you can't say, don't look at my document, look at the discharge summary for my wounds and for my other things, but don't look at that for other part of the purpose. No,
well, if the insurer would have taken one contention that it is not occurred accident as contended, it is fall from bike. If it is the contention, I would have done this, all this my lord, before the trial court. Because primary burden is discharged by producing the police
you only,
records.
how you are discharged by producing two documents?
My lord, apart from this, my lord, there is simple one observation that fall from bike. Who has given information to the doctor? It is not.
And even who has given the first information has given the second information.
But wound certificate prevails over the my lord, subsequent document. Wound certificate's primary.
MLC extract will prevail over the other documents. Where is the MLC extract?
But that was not my lord, produced. My lord, even otherwise, my lord, the insurer has not my lord, produced any document and my lord, no evidence.
Forget
oral
about the
evidence.
insurer. Let us ask what is about how you have discharged your burden.
My burden is
When
discharged by producing.
two documents are contrary to the other, it's for you to explain.
Please.
Or else you shouldn't have marked it.
My lord, not only two documents, my lord, to discharge my burden, I have produced, my lord, all the my lord, police records, wound certificate, medical record, IMV report, smart master also there is indication.
In the normal this thing, it would have been court. It would not have been a gliding aspect. But under the circumstances where you have given a complaint after 5 days, in those circumstances, we have to look at all this.
And my lord, the document which is beneficial to the claimant has to be taken into consideration, because whereas other police, the independent authority has conducted an investigation and my lord, filed charge sheet. My lord, this my lord, that prevails, my lord. And there is a clear explanation in the delay. My lord, occurrence, my lord, he has suffered injuries. My lord, there is medical records also there. My lord,
Yes,
if
Mr. Krishnan.
there is no contention in the written statement that it is fall from bike, it is not my lord, RTA. If it is, it was.
My lord, ultimately, these cases, we would be encouraging a sort of misrepresentation that was committed, and it appears to me that it is a case where he fell down from a motorcycle. Subsequently, they want to see that.
You should do something instead of
being
pointing out at his lapses. Your insurance company should also do something.
My lord, these happened in 2009, 10.
No, nobody can do anything about it. Yes, please.
My lord,
come.
one document that runs contrary to him, one more opportunity could be given to him, so that I don't know. This is what I felt, that if an opportunity is given, let him substantiate by examining the
He
rider.
cannot in 2009, 2020.
My lord, rider,
Huh?
the person who was walking with him, he must be examined. The two persons were walking according to them. One person suffers injuries.
He will give evidence as how because he is
And
his
even,
brother. No useful purpose in
my
that
lord,
also.
one more document that
Yes.
is produced by them is history of fall from bike, complaints of pain. This is also available on record. One more document is also.
What is that?
This is also history of the admission history. At the time of admission before the hospital, Occurred hospital, they have given this history of fall from bike.
Exhibit?
My lord, this is
Continuation.
no, not continuation. This is another document, 16, my lord. Exhibit P16, 15.
Yes, no, you have changed, you have gone to two hospitals. Now the discharge ceremony is of which hospital?
Both are Occurred hospital only. Occurred hospital, admission time also they write it.
Every
And
time,
also in discharge also they
Doctor
write
will-
the same thing. And he produces both the documents.
once
And he
admitted,
admits in the cross examination, yes, I have given
Patient-
how it accident happened.
once patient admitted to hospital, my lord, the doctor will not again and again ask how the accident happened. First admission.
First of all, you are admitted in one hospital. Then you have come to, according to your own, your brother or co-brother, he says thereafter he was taken to that Occurred hospital. When you went to the Occurred hospital, you had enough time. By the time you were also conscious. Now let's see, in the judgment it is there. Let's see.
Please.
Page number 11, para number 11.
Please.
There is a delay in filing the complaint.
Respondent number 2 has taken up a specific contention that there is a delay in filing the complaint, but the perusal of the complaint exhibit P1 shows that it is lodged by one Harish, who is said to be brother-in-law of the claimant and eyewitness to the alleged accident. And the complaint has clearly stated in the complaint that immediately after the accident, he had shifted to the claimant to the private clinic at Nitturu, and thereafter shifted to the
So,
car.
at the time of admission, when you were taken to the Oakard hospital, you said it's a fall from bike. And the same you find place in the discharge summary. Let's take even discharge summary, let's not look at, but admission, your brother-in-law only taken you to there.
My
Who
brother-in-law
was
was
there along
taken.
with you? Who was assuming that you have not said so? Your brother-in-law has admitted you in the hospital, he said so. You want to look at that admission, that exhibit,
16.
give it to him.
Please.
Look at it, look at the document.
Please. First information is being copied in every further documents.
First information is important in admission. At the time of admission, your brother-in-law has given, then all the more significance it has. He is the one who is walking along with you on the road. He told. He only says he has taken you to the hospital. Please come. That is exhibit, admission card is exhibit?
P16.
P?
P16.
And the discharge summary is P?
15.
P7. Discharge summary.
P15 is discharge summary.
Agreed with the order passed in MVC number 1444 of 2009 dated 26 December 2013. Both the insurance company as well as the claimant are before this court. The insurance company's appeal is MFA 2205 of 2014 and claimant's appeal is MFA number 3091 of 2014. The claim petition is filed seeking compensation of an amount of rupees 5 lakhs for the injuries sustained by the claimant in the accident. It's a case of the claimant that on 8/9/2009 at about 9 a.m., while the claimant and his brother-in-law were proceeding by walk in front of the house of one Mariappa, a Hero Honda motorbike came with a high speed in a rash and negligent manner from the backside of the claimant and dashed against him, on account of which he fell down and sustained injuries. Immediately, he was shifted to a private hospital at Nittur and thereafter to Oakard Hospital, Bangalore. The brother-in-law, who was walking along with him, has taken him to the first hospital and thereafter to the other hospital. The court on the issue of liability has held that it is a case of the insurance company that the belated complaint is given after 5 days and it is unexplained and the vehicle is not involved in the accident. Court had held that the insurance company is liable to pay the compensation on the ground that there is reasonable explanation for not giving the complaint within 5 days and the police records also supports the case of the claimant. Hence, the vehicle is insured by the insurance company and the insurance company is liable to pay the compensation. When it comes to the compensation, court had granted an amount of rupees 1,05,800 for the injury sustained by the claimant. Next para. The claimant is before this court seeking enhancement of the compensation, and the insurance company is questioning the liability of the insurance company as the claimant has failed to prove that the said vehicle is involved in the accident. Then counsel appearing for the insurance company submits that Exhibit P16 is a admission card and Exhibit P15 is a discharge summary of the Oakard Hospital. As for that, it is a fall from bike. The exhibit P, what is the
4.
exhibit P4? Wound certificate says that injuries it's in a RTA. It is a contention of the learned counsel that the delay in giving the complaint for 5 days this particular vehicle is implicated in this case, as the vehicle on which they are traveling is not having is implicated in this case. It is submitted that the brother-in-law was not examined. Complaint is given after 5 days without a proper explanation, and the brother-in-law who was deposed that he has taken the complainant, taken the claimant to the hospital and they had admitted him. And as per his own, as stated by him, they have recorded it as fall from the bike. According to the learned counsel, this is a misrepresentation with all suppression and misrepresentation of facts. The claimant had approached the court, and the claim petition ought to have been dismissed. Next para. Then counsel appearing for the claimant submits that the claimant had discharged his burden by by examining PW2 and by marking exhibit P1 to P17, land counsel submits that is never the case of the insurance company, that the vehicle is not involved in the accident, and without taking any grounds before the trial court, it is not permissible for them to raise all these grounds before this court. Before it is submitted that the compensation that is awarded by the tribunal is not a just and reasonable compensation, and then the same needs to be enhanced. Next para. Having heard the counsels on so and so. The first coming to the aspect of liability, no doubt all the police records are in favor of the claimant, showing that the accident had taken place, and they have filed a charge sheet against driver of the offending vehicle. The claimant had relied on exhibit P4 and exhibit P15 and 16. No, it says discharge summary, discharge slip.
That is not discharge slip, that is admission card.
The exhibit P15 and P16, that is the discharge summary and the admission card. Admission, the Wokhard Hospital admission card and the discharge summary speaks about a fall from the bike. The wound certificate is issued by which hospital?
Same hospital.
Same hospital on 510. They say that alleged.
The wound certificate is issued by the very same hospital. The 3 documents are running contrary to the other. In that case, the claimant ought to have examined the concern. In the light of the delay in giving the complaint, the submission of the learned counsel that the documents which are in favor of the claimant has to be looked into, that this court is not able to appreciate. When an application under 166 is filed, the claimant has to prove that there is negligence on the part of the driver of the offending vehicle and the accident had taken place. When his own documents or 2 documents are not supporting his case, and 1 document and by the very same hospital, and they're all speaking different versions, the responsibility lies on him to examine the concern in support of the same, which the claimant had failed to so. In view of the above discussion, this court is of the view that there are merits in the contention of the insurance company, and the claimant had failed to prove the accident. In that view of the matter, the order passed in MBC number 1444 of 2009, dated 26 December 2013, is set aside. The amount in deposit shall be transferred to the trial court, and the insurance company is at liberty to withdraw. Yes, next.
I deposited here, it may be refunded here.
Here only. Not to transfer. The insurance company is at liberty to withdraw the amount. Yes.
Cell number 9. Mahesh for appellant.
Serial
I
number
appear
nine,
for
respondent.
appellant.
The counsel for respondent number 3, 4, and 5 is no more, my lords. Kindly issue notice to respondent number 3. Vinod Kumar C is no more.
We'll hear him first.
Please.
On what ground these appeals were filed?
But that there was no insurance cover,
Hmm.
and both owner and the insurer were placed ex parte, and application filed for this thing, my lord, was rejected. Therefore, my lord, MFA
Submitted
20
that. The counsel appearing for
Respondent number 3, 4, and 5.
respondent number 3, 4, and 5, or whom? Or the claimants?
Claimants.
3,
Respondent
4,
3,
and 5.
please.
There's no more. Registry is directed to issue notice. Business matter after service of notice. Yes.
Cell number 10.
Delete from part third.
Yes.
Yes, next.
Cell number 10. Pradeep B for appellant.
Appearing for the appellant,
Krishna.
Yes, Pradeep. This is?
challenging involvement of the vehicle, my lord. This matter has heard from my side, my lord. The accident has taken place on 7/10/2010.
Mm.
The complaint lodged on 2/11/2010, my lord, after 25 days from the alleged accident. My lord. The police, after thorough investigation, have filed a not filed a charge sheet. Not the accident information report, which the complaint itself is in wrong and mistake of facts. Therefore, the IO has been examined as RW1 and who has categorically stated that which the Pulsar motorcycle is not at all involved in the alleged accident. Therefore, they have filed a B report, my lord, stating that
let us
vehicle.
read from
Para
the
11 onwards, my lord, there is a discussion. They have examined the eyewitness as PW2 on Munraju. Para 11 onwards, there is a discussion. The MSCT coming to the conclusion that, my lord, the investigating officer who has conducted the investigation, who has not been examined, some other investigator has been examined. Therefore, the liability fixed against him.
No, but the report is
Report
filed.
is there. Report is exhibit
Whoever it
R1.
is.
Report is R1. Exhibit R1. Para 15, my lord.
But let us read from 11 to understand the facts.
Please. In the cross-examination, he has stated that is IO, my lord, not my
Yes.
lord. Investigation officer is respondent number 1, RW1. He is said to be an eyewitness, PW2. In the cross-examination, he has stated that he was standing near the tea stall at the time of accident. He has told the police that he has seen the accident. Police have not taken written statement in the spot, and they have also not written down his statement. However, he has specifically stated that petitioner's son was not present at the time of accident, and however, petitioner's sons came to the hospital. He has also deposited that he did not notice whether the rider of Pulsar motorcycle was present near the accident spot, but the rider was aged about 40 to 45 years. He has voluntarily deposed that many people gathered
Have you questioned the final report?
No, my lord.
Then they say that when the complaint is given,
Yes,
they said it's on a mistake of facts, they filed a final report.
Yes, my lord.
That should have been questioned by you.
My lord, but the investigating officer, he was not examined.
Forget
my lord.
about the investigating officer.
Yes.
The document is, that exhibit R1 is the document. It's a final report.
Yes, my lord.
Unless and until that final report is questioned by you, then and otherwise, how did you prove the accident? Police documents are against you.
No, my lord. The accident is not in question, my lord. He has occurred the accident. He's got injuries. Medical bills have been produced, my lord. Only the negligence is in question, my lord.
Very involvement of vehicle is questioned. Pulsar motorcycle bearing number so and so is not at all involved in the legend. And we have taken specific contention also in the return statement, para 10 of the return statement.
Okay. Afternoon. Afternoon. Next matter.
Awesome. Cell number 11. Tejas Rai K for appellant.
You are on what ground?
I appear for the appellant.
It's only on purely on the ground of quantum.
Quantum. Where is the table?
Please be.
Page number 13.
49,800, the medical expenses which they have incurred, as per the exhibit P4, my lord, wound certificate,
One
they have
minute.
sustained
How many are the injuries?
3 injuries. My lord.
How many are grievous?
No grievous, my lord. As per wound certificate, all are simple in nature.
Exhibit P 25 disability certificate is there.
I'm asking about the simple injuries, nature of injuries.
Two type injuries.
Huh?
One left hip is dislocation of left hip and fracture of head
Please
femur.
come from the, read it from the order.
Doctor not examined, my lord. Only dispute.
It has come in evidence of PW1 that he was admitted in the Omega Hospital, Mangalore, and took treatment. There is inpatient from 7/3 to 27/3. During that period, he was subjected to close.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯೂಟ್ ಆಗಿದೆ.
Yes. Yes. Yes.
Doctor has not examined.
Then food
ಕೋರ್ಟ್
certificate.
ಆಫೀಸರ್ ಕೋರ್ಟ್ ಮ್ಯೂಟ್ ಆಗಿದೆ, ಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ಡಿಸೆಬಿಲಿಟಿ ಅನ್ಮ್ಯೂಟ್ ಆಗಿದೆ ನೋಡಿ, ಅದು ಯಾರೋ ನೀವೇ ಮಾಡ್ಬಿಟ್ಟಿರ್ತೀರ ಅದು.
ಇಲ್ಲ ಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Ask somebody to be here when you people are not able to operate that. Huh? You ask them somebody to be here. Yes.
Disability certificate only on.
But without examining anybody, contrary to the wound certificate, and you're saying some other injuries, and you say and you place a disability certificate, you don't examine anyone, how the court will consider all that? All are simple in nature, as per the wound certificate, very document filed by you.
Disability certificate 20% partial permanent disability is there.
How that document be considered without examining the doctor?
Future earning capacity also not at all.
Yeah, nothing can be done. Loss of amenities in life and discomfort, medical expenses. What about medical expenses?
That's what, my lord. Medical expenses 49,800 has been awarded. They have not substantiated that, my lord, whether the medical expenses they have incurred for the accidental injuries or not. They have stated that, my lord, he has admitted to the Omega Hospital in Mangalore. In Adichunchanagiri Hospital, Mandya, the wound certificate which has been issued, it doesn't reflect that, my lord, whether he has sustained fractures or not. Only simple injuries has been mentioned in the wound certificate. Then, my lord, they have to substantiate that. After that, what has happened?
Yes, madam.
Exhibit P25 reveals that petitioner sustained dislocation of left hip which is grievous in nature. The petitioner is having partial permanent disability under the circumstances.
No, that's what I'm saying. Certificate will not be considered without examining the doctor. And when the wound certificate says simple injuries, suddenly where from that grievous injuries have come? If at all, who has treated you? Have you examined anybody? And how can the court consider a disability certificate? And how did the court grant this loss of amenities in life and discomfort? Basing on what basis? Medical expenses also. First of all, there should be an injury, then the doctor, then the evidence.
Mm. 20 days he was in hospital, Your Lordship.
What did
Omega
you
Hospital,
produce?
he was in 20 days.
What did you produce? If you have simple injuries, why you will be in the hospital for 20 days as per the wound certificate? There must have, something must have happened thereafter. That document you didn't place on record.
Prescription receipt is there. Prescription receipt is there. Discharge bill
I am
is
not
there.
convinced. If you want to convince the court, look at it tomorrow.
Now only you dispose, Your Lordship. Now only we decide, Your Lordship.
Shall I dismiss it?
At least medical attendance charges also on 10,000 granted. Actually, he was in 20
Please
days.
understand. I'm going to reduce that compensation. That's why I'm giving you time. Understand that. That's why time. Or else, if you want me to pass orders, right now I'll pass. But it won't be enhanced. The amount will be decreased, reduced.
Your Lordship, please don't be reduced. Whatever it is there, it's.
Then what will happen to him? He has filed appeal. Then court has to record reasons why.
Please, Your Lordship, don't be reduced. Whatever it is there, that's.
What do you say, Vijay?
What about my appeal?
What do you say?
My lord,
He
actually, my
wants
lord,
it not to be reduced.
except my lord, medical expenses, my lord, rest of the amount may retain, my lordship.
That's a major chunk.
49,000.
Yes, sir.
That they have not
50,
ruled, my lord. That's
about
why.
50, maybe 45, 47, 48 years.
He wants it to be reduced.
Your Lordship, please, because already he's a 20 days in hospital bill, discharge bill, disability certificate, doctor only. Your
Does this
Lordship.
matter on 17th of June? Yes. Yes, next matter.
Cell number 12.
For the petitioner in this matter,
Welcome,
kindly pass over.
Password. Yes, next.
Orders matter, cell number 13.
Connected matter, my lord, I am for the appellant, my lord. Matter, my lord, I am unable to serve the copy, my lord. He is not appeared and not the Chandrasekhar, my lord. Chandrasekhar in connected matter, my lord. In the connected matter, my lord, I am for the appellant 1664 of 2016, my lord. I filed amendment appeal memo.
Who is Mr. Chandrasekhar?
The insurance Cholamandalam DBS Finance Limited company. It's represented by the.
He appeared online in the morning.
No, my lord, he's not appeared last case and also before last case and also.
Venkatesh is not coming.
He's not regularly counsel.
Chandrasekhar SN.
My lord, he's not regular appear counsel. This is not insurance company. This is financial company.
What is that finance? Cholamandala.
Cholamandalam DBS Finance Limited.
Then what is to be done? No representation.
I filed the amendment appeal memo, my lord, in connected.
File in the section.
My lord, because my lord, I am unable to serve the copy, my lord. It's not.
What to do? 13.
Count was.
There is no representation. List this matter for dismissal tomorrow. Tomorrow he will come, then you serve.
Much.
Cell number 14.
I appear for appellant, my lord.
Who appears for AR Mahesh?
Translation is filed, my lord, on 21/3/25.
List this matter on 10th of June. Yes.
Cell number 15. D. Vijay Kumar for appellant.
Respondent.
Veerabhadraya.
Where is Mr. Vijay Kumar? For dismissal tomorrow, no representation. In MFA number 2041. Yes, next. No. This one, there is a 2019 is there. So these matters, 15 for dismissal. Non-compliance of office objections. In your case.
Second matter, my lord, file a memo. Sorry, withdraw.
You want to withdraw. Where is the memo?
Instead of hearing, instead of hearing,
You will file a memo.
file a memo.
And then list these matters to for dismissal tomorrow. Yes, next.
Serial number 16.
Bring for respondent, my lord.
No representation for the appellant. This is matters on 17th of June. Yes, next.
Please.
Serial number 17. Hearing on IA.
In this case, I appeal for the appellant, my lord. I made an application to send back the LCR to the trial court in order to take the FD, which is already matured.
So and so, IA number 1 of 25
Respondent, my lord.
is allowed. The registry is directed to the TCR to the trial court. Yes.
It's much obliged.
Yes.
Serial number 18. Serial number 18.
My lord, I am respond number, claimant filed.
No representation for the appellant. List this matter for dismissal tomorrow. Counsel for the respondent is present.
I filed IA for.
Hey, that's it. Tomorrow we'll hear it. He has to be here. Yes, next.
Serial number 19. Jaguar.
IA number 1 of 22 is filed to condone the delay of 124 days. They say no objections are filed. The same is condoned. List this matter, admit, list this matter for final hearing. Next 19.1, delay of 1 day condoned. Both the matters, list of TCR is there. A call for the TCR. Yes, next.
Serial number 20. Procedural for appellant.
Where is the counsel for the respondent? Who appears for the insurance?
Last occasion, they only, she only taken time.
Who is the contesting respondent in this?
Both mallards. Both two involvement of two vehicles.
Lingaraj was here just now. Pass over. Will pass over.
Serial number 20. Pass.
Yes, Mr. Lingaraj. You're ready? Password?
Password. Liability is not on me, it is on the other way.
Who is appearing for that?
Shishaila.
No representation for the respondent. Counsel for the appellant is present. List this matter as part of tomorrow. Even if he's not there tomorrow, tell him we'll pass orders. List 21.
Serial number 21.
I appear for the respondent claimants, my lord. In the cross objections, I had to file wakalat for
IA
the
number
claimants.
1 of 16 not pressed.
I appeal for appellant, my lord.
What is this? IA 1 of 16. Substituted service.
All the respondents were served.
Look at it. What is this IA number 1 of 16?
All the respondents have entered appearance. Srimati Kavita for R1 to R2 and Mr. Natraj Malad for R3.
Yeah. IA number 1 of 16. And counsel for the appellant submits that. And he is not pressing IA number 1 of 16, which is filed to substitute service of notice on the respondents, as all the respondents are served. Next, what is in crop? MFA crop 21.1?
And to file the transaction that is already filed by Mr. Mahesh.
And counsel appearing for the you are for the respondent, appellant for the cross objector submits that already the translated copies are filed with the end counsel for the insurance company. In view of the same, no document, no translated copies are required from his side. Is ready?
Yes, ma'am.
Yes, Mr. Mahesh.
Yes, madam.
Yes.
But the copies are not served. That's the reason, my lord, why I am not able to this thing.
Everything is solved.
Even
In
the
the
last occasion also the same thing is you represented, I think.
Let him show the, my lord, the.
I have an acknowledgement. I will get it because.
Please we will give it what is happening, we'll see. Why in every case the same representation is coming? Please show. Yes, Mr. Mahesh, is it not your signature?
No, I can't.
Show it to him.
No, it is not visible. It is not visible.
This, sir.
No, what is the mode of, you must be having the email.
One minute. Yeah, that is my signature. That is my signature.
Then why are you saying that it is not served?
No, it is not kept in the file by my assistant, my lord. That's the reason I think.
Then it won't amount to not serving of the papers. This is matter tomorrow.
Yeah.
And tomorrow the matter will be heard. Yes.
My lord, one submission.
22.
One serial number 19 to be disposed of, my lord. Serial number 19. Connected appeals are already disposed of, my lord. Hence, we are moving the matter, my lord. Come on. P. Pradeep is there.
19.
Yes, my lord. It may
Tell Pradeep, 19 in the afternoon.
faster, ma'am.
Yes.
19.
Yes, next.
Cell number 22.
Appear for
Oh, Mahesh,
fourth and fifth
apply.
respondent, my lord.
Yes.
Right,
Yes,
in
22.
this case, my lord,
You
in
that.
MF 7561 of 2017, my lord, claimants have been served. In MFA 7562 of 2017, my lord, they are responding 2 and 3. So my request is, my lord, to hold the service sufficient on, my lord, R2 and R3 in MFA 7562 of 2017. Otherwise, I'll make a separate application, my lord. R2 is Soumya, R3 is the, my lord, Venugopal.
So 2017. This is matters on 11th of June. Yes.
Please.
Cell number 23.
Yes.
Cell number 23. Harish Bandari T for appellant.
Sorry.
N. Krishna Swami.
What is the urgency in this memo is moved and the court is not hearing this 2017 matters only till 16. We'll give a date for this. This is matter on 11th of June. Yes, 24 also. Admit post of final hearing on the date.
ECA matter.
Huh?
ECA.
ECA matter or not admit post this matter on so and so date. Yes, 24.
11/6.
24th April. Yes.
11/6, sir.
24.
No, 8th.
April this one 24.
This is matter on 10th of June.
10th of June.
23rd, Your Lordship.
Huh?
23rd date.
10th of?
23rd, Your Lordship. Date.
Because it's also 10th June.
Yes, please.
And
10th.
Yes.
list number 3. For orders matter, sale number 1. Shami.
The first, this one, it is unclaimed, which can be taken as an served. And second time, it has not come up.
As per the postal shara, notice to respondent returned as unclaimed amounts to deemed service of notice. Yes.
And this is about transfer of petition,
From?
which is more than 250 to 300 kilometers from Bangalore to Shimoga. We sought for transfer.
MC of which year?
MC is in Bangalore only.
Year.
Year of 2024. MC number 142 of 2024.
Children in the wedlock?
When?
Children. The couple are having children.
Oh, she is having a child.
Raghavendra was proceeding on his motorcycle.
She is having a child. Man.
Present petition is filed seeking transfer of MC number 142 of 2024 pending on the file of the second additional Principal Judge Family Court at Bangalore to the Principal Judge at the MFC Sadra at Shimoga. It is submitted that the marriage is solemnized on 30/10/2006 at the Siddha Ganga Mat Temple, Tumkur. And thereafter, in view of the differences between and in the wedlock, they're blessed with a boy who is 3 years old. In view of the differences between the parties, the wife had started had filed a petition on section 125 of the CRPC, and the same is on the file of the Principal Civil Judge and JMFC at Sagara, Shivamogga, that is criminal miscellaneous number 108 of 2023. Thereafter, the husband had filed MC number 142 of 2024 in the court of the Principal Judge Family Court at Bangalore. It is submitted that next file it is submitted with land counsel for the petitioner that the distance between Bangalore and
More than 250 kilometers.
Bangalore and Shimoga. What is this place? Shimoga.
Shimoga.
Shimoga is about more than 250 kilometers, and the wife has to take care of the child, and it's difficult for her to travel next para. Though notice is served on the notice to the respondent has returned as claim, and this court had held it as sufficient service of notice next para, as deemed service of notice. Having heard the land counsel for the petition for a material non-record, considering the fact that the distance between both the places is about 250 kilometers, the wife has to take care of the child. This court deems it appropriate to allow the petition. Accordingly, so and so is withdrawn and allowed. Next is the wife shall cooperate. All the conditions should be common. Yes, next.
Cell number 2, Usha Devi KG.
No, already wakalat is filed. Why they say avoid service of notice? Notice to the respondent is already served. Let them at least verify before posting. Tell the registrar judicial what is happening. No representation for the petitioner. List this matter for dismissal tomorrow. Next.
Cell number 3. Cell
Same.
number 3.
No representation for dismissal tomorrow. Next.
Cell number 4.
Memo for retirement in this matter, my lords. I appear for the petitioner in this matter.
What is this memo for retirement?
My lords, the previous advocate have filed in
Fine.
for retirement.
The
I am
memo of
now-
retirement is filed by Mr. Chaitanya V. Joshi, and the same is taken on file, and the so and so is permitted to retire, and as already the other council has filed for Kala. Yes. No stay in this till now.
No, my lords, there's no stay.
Let it wait, which is waiting from 2024. The
Also, another
petition.
connected matter with this. my lords. Another matter is also there, which is similar.
Give
There's
that
also-
number. Who is filed by whom?
Same wife is filed, my lord. CP in
Take
which notice is already.
list along with that.
Yes.
And in both the matters, the counsel for the petitioner shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 24th. If it is filed, list this matter on 28th.
Correct.
Yes.
Cell number 5. Sriram Babu.
For petitioner, my lord, in this case. I'm sorry.
Respondent number 1 to 4.
What is it?
This is indigent appeal. I'm asking for to treat the indigent appeal because the plaintiff case of plaintiff is dismissed in the trial court. She has to file a 48,000 rupees court fee for the appeal. She is not having a movables and immovable property except the litigation property. She is a very poor person and she wants to continue as an indigent appeal.
What is it?
My lord, along with my statement of objections, my lord, as per the averments made by the plaintiff in the plaint itself, which shows that she is having a property in her name. Your lordship may kindly see annexure R.
Page number.
Along with my statement of objections.
This is in Kannada.
No, my lord, it's in English.
No.
Along with my
complaint, or what is this?
Along with my statement, I think that is the report of the Tashildar.
A statement of objection.
Statement of objections of respondent number 1 to 4. Page 5th, page number 5, my lord. This is the plaint presented by the petitioner before the trial court. Your lordship may kindly see the dispute involved in the suit, which measures east to west 20 feet and north to south 31 feet. Your lordship will get it in page number 9 of the schedule. Schedule is mentioned as east to west 20 feet, north to south 31 feet. That is the subject matter of the suit filed by the petitioner here. Your lordship may kindly see page number 6 in the plaint. The plaintiff.
What is the plaint?
Plaint at page number 6, Mila, annexure R1. along with my statement of objections. Page number 6, para number 2. The plaintiff, that is the petitioner herein, the plaintiff is the owner of the property and has been possession of the property of door number 1576, Batarayanpura CMC Kata number so and so, Sanjeevini Nagar, Kodihalli village, Yelanka Hobli, measuring east to west 37 feet, north to south 31.5 feet. And thereafter the Chekkumandi west by road, south by road, north by Chikkahuchaya's property. In this site, the plaintiff constructed two portions of the house in this site consisting. So according to the plaintiff averments, my lord, the entire extent of the property is east to west 37 feet and north to south 31 feet. The subject matter of the suit, which measures east to west 20 feet and north to south 31 feet, that is in my possession. The half possession of the property is with the petitioner only. So now she is saying that she is not owing any property and seeking permission to prosecute the appeal as an indigent person. The statement made by the petitioner is false.
What is your reply to this?
My lord, for this one, entire property is a portion of the two portions.
File your objections to that if you are denying it.
No,
Your reply or rejoinder, whatever you.
I'm now just now I'll reply for this. So in two portions were there. One portion.
File it, let it be on record.
Rulings may be taken, my lord. I told submitted the on ruling, two rulings that may be taken on the record today. Judgments, rulings. Next time it is convenient for me to argue.
That will be, let me say. This is matter on 22nd.
After vacation, kindly run.
After vacation. This is matter on 12th of June. At the request of learned counsel for the petitioner. When was the notice sent? Look at it, 6.
Number 6.
My lord, I appear. Kindly pass over, my lord.
1 minute. Not from that. You can see it from the. No. What is the office note? When was the notice sent? Then what is the stage? They have to verify. 17.3. List after service of notice. Yes, next.
Obliged.
Serial number 7.
No representation for dismissal tomorrow.
Serial number 8.
What is the refuse to respondent?
Steps to be taken in respect.
No, notice to respondent returned with an endorsement refused amounts to service of notice. This is matter tomorrow. Yes.
Serial number 9. Harsha Kumar Gowda.
No representation for dismissal tomorrow. Yes, next.
Serial number 10.
Please press for a time, my lord. Kindly.
After service of notice, as per the cost list, notice awaited in respect of R2 and R3. This is matter after service of notice.
Serial number 11.
Much obliged.
11. Tardamba Air.
This is land acquisition case, my lord. I have filed an application.
So have a copy on them.
Once I have given, I will give. It is here only. I will.
Yes. B.R. Prashant takes notice in respect of the IN number 4 of 24 is filed to implead the beneficiary. Mr. B.R. Prashant takes notice on behalf of Nilavari Nigam. Kaveri Nilavari Nigam. Then accordingly, IN number 4 of 24 is allowed. And the petitioner appellant shall make out necessary changes, necessary amendment to the cost title. List this matter on 8th of April. By that time, can you file amendment?
I will file cost title amendment.
Registry is directed to reflect the name of Mr. Prashant.
Is it sufficient if I buy the cost title only? Cost title only.
Amended cost title.
Please, I will buy.
Yes, next.
Cell number 12.
Please.
Next.
I have furnished the paper publication.
Acceptance of
Newspaper, I have
substituted
taken
certificate
steps, sir.
of R3. Venugopal, Ravi Kumar,
Yes.
Ramalingappa,
Same, a memo is taken
Sharana
on
Siddhaya.
record and it's coming up for acceptance of the paper publication, same as accepted, and notice to so and so is held sufficient. Yes, next.
Yes, madam.
13.
12.1 same.
Yes.
And
13.
list these matters for final hearing.
Yes, sir.
13, I am appearing for the appellant, my lord. I filed a memo on 25/2/25. 28/5, my lord. In that memo, I stated, my lord, respondent number 4 is represented by counsel. Respondent number 5 is brother of respondent number 4. He can as well be directed to take notice.
Have any instructions?
I have
We
no
cannot,
instructions.
because
I have no instructions.
R4 ಗೆ ನೀವು
They ಬಂದಿಲ್ಲ. I cannot.
R5 is his brother. So that it will,
we can't compel him. If he takes, it's fine.
if he takes, he can verify it and make submission.
Last time also same submission is made. I checked.
ಇಲ್ಲ. This
Shall
is
be
the first
taken
time I'm making.
For issuance of notice to R,
4, all R5.
notice to R5.
Hmm.
What about 14 to 16?
14 to 16, they may be deleted, my lord. I filed them.
File a memo.
That memo is there in the same memo.
Please file seeking dispensation of notice to R14 and 16. Same is taken on record and memo to the notice to R14 and 16 as dispensed with. List this matter after service of notice to R5.
My lord, it may post it for admission. Subject before that, he can, if he takes a decision.
Right from 2023, this is happening. Take out notice. Yes, 14.
Cell number 14. Hearing on IA.
For the petitioner, my lord. Annexure C to J may kindly be dispensed certified copies of annexure C to
What
J.
are C to J?
C to J are certain FIRs that were pending between both the petitioner and the respondent. They are the husband and wife, my lord.
Yes, what is
The prayer is, my lord.
25 is file seeking dispensation of the protection of the CC of the annexure C to J. Same as IA number 1/25 is allowed.
In short, the list is this, my lord. My prayer is for transfer of the subject MC petition filed by my husband in Kalburgi, my lord. No doubt we both have got married at Kalburgi. From 2018, my lord, with cogent documents that are produced before this honorable court, both of us are staying in Bangalore. I've also produced the Aadhaar card of the respondent here in my lord. That is at annexure.
When is the MC filed?
MC filed is in the year 2025. Kindly, my lord. MC is filed on 8/11/2024. We have been staying together since 2018 in Bangalore. There is an FIR registered against the respondent in Bangalore. A counter FIR is registered against me in Bangalore. I have filed anticipatory bail in Bangalore. On my FIR, my lord, I have filed a criminal petition under 528 of the BNS and secured a stay. All those copies are before this honorable court.
No, the present petition is filed seeking transfer of MC number 59 of 2024 on the file of the senior civil judge JMLC Chincholi, Kalburgi, to the third additional family court at Bangalore. It is submitted that the marriage had taken place in Kalburgi and right from 2018. Both the wife and husband are residing at Bangalore, and several cases and counter cases were filed before the courts at Bangalore.
And children are also studying in Bangalore.
Children are studying in Bangalore only for the purpose of harassing the petitioner wife. The petition is filed at Kalburgi, considering the reasons considering the reasons stated and having heard the arguments of the land counsel for the petitioner and the fact that as it is stated that both of them are residing in Bangalore, they shall be stay of all further proceedings in so and so till the next date of hearing. Hand summons.
Please.
The counsel for the respondent before the trial court by 25th, and list this, and if the memo is filed by 25th, list this matter on 28th, or else the stay granted by this court stands vacated.
Highly apply.
15. Satish SP.
Yes.
Petitioner, my lord.
Appearing
The
for the
matter may be
respondent, my
referred to mediation, my lord.
Who appears?
Respondent, my lord.
Can be
Kindly
referred?
please refer it to mediation, my lord.
Where? Bangalore.
Bangalore.
Both the parties submit that there is a likelihood of settlement. This is directed to, hence the matter is referred to the Bangalore Mediation Center. This judicial is directed to communicate the same. They shall appear before the mediation center on 22nd April at 3 p.m. Yes, next.
Cell number 60. Somnath H for petitioner. Ajit Kumar.
Appear for petitioner.
Yes.
This petition is filed by the husband seeking transfer from Doddaballapura court to Mandya court, my lord, which is approximately 150 kilometers, my lord, at one stretch. Husband is seeking transfer based on medical grounds, my lord. He is suffering from backbone injury, my lord. He is advised not to travel by the doctors, my lord, which I have produced along with the petition, my lord. Kindly come to page number 60, my lord.
That's one reason. That's the only reason.
Please, my lord, only based on medical grounds, my lord.
My lord, he is working in Bangalore itself. He is he's working as a software engineer. And there are 3 more petitions pending in the Doddaballapur court, which is for seeking interim maintenance and for recovery of the interim maintenance, and 1 more revision petition filed by them, which is also in Doddaballapur. And she is a lady, and it would be she is dependent on her parents, and it would be inconvenience for her to travel to Mandya every time. And if this MC is allowed, again he'll come up for transfer of those miscellaneous petitions as well. Therefore,
what are the medical reports?
My lord, I have produced that there are no children born out of the wedlock, my lord. My lord, kindly come to page number 67, my lord. It starts from page number 62, my lords. Advice.
No, doctor's advice.
Please, my lord. Avoid forward bending and weight lifting. Page number 62 of my petition.
Yes.
Advice, my lord. May I read, my lord? Avoid forward bending and weight lifting. Avoid spring and foam mattresses. Avoid long distance traveling, my lord.
Forever.
Please, my lord. And recently, he has been taking care of all these medicines, my lord. Recently, has been subjected to MRI scan, my lord, which is I produced here, which is a stage 3. Now, recently on February 25th, I'll just pass on the medical records, my lord. He has been advised to undergo surgery, my lord. It is at 24/2/2025, my lord. Recently, exactly a month back, my lord. Both hip tenderness plus joint line deformatory, present movement, abduction received, my lord. And he has been advised to take an opinion from Dr. A.J. Srinivas. He is also an orthopedician, my lord. And at page 3, my lord, advice recommending core deformation of both hip and bone implantation, my lord. And estimation is also given at 4th page, my lord, which is on 27/2/25.
Commissioner
He had
may
to
be
undergo
appointed
surgery
for
as well.
the evidence, my lord. A commissioner may be appointed for evidence if at all his presence would be unable to travel or to be present.
But this matrimonial matters, the presence of the parties is very much necessary for the evidence. You cannot, you can't do it with the commission cannot do it. The court has to see the demeanor of the witness and how it is going on.
And one more case is pending at Mandya, my lord, CC, which wife has only filed, my lord, 498 complaint, which is pending at Mandya, my lord. And MC is filed until 2023.
These documents are not correct, you can. But as it is, it appears that then why don't you file a certificate by the doctor concerned who is treating you?
Please,
what
my
is
lord.
the present state of his?
I'll place it on record, my lord. On the doctor's advice, I'll place it on record.
At the request of no, tell your client it would be if that is the critical health condition, we can't expect him to travel.
He's work from. He is taken from work from home.
If she has to travel and whatever the expenses, whatever she requires and everything, we'll see to that.
He is not at all giving the maintenance, and we have filed a series for recovery of maintenance.
That we cannot decide it here. As far as the travel expenses and other things are concerned, you can come up with the instructions. Because the health condition as it is appears to be something not right.
Please, ma'am.
Yes.
This
is matter.
Travel expenses we can bear, my lord.
Matter on 21st of April.
Please, ma'am.
Interim order is there.
Please, my lord. Interim
order earlier granted is extended.
Please.
Cell number 17.
I appear for the petitioner. It's a wife petition, my lord. The petition. The respondent is filed a petition for under section 9 of the restriction of conjugal rights at Hassan, my lord. The petition is
Hassan to where you want it?
Bangalore, my lord.
Distance?
Distance is 200 kilometers, my lord.
Land Council for the present application is filed by the wife seeking transfer to the MC pending on the file of the family court at Hassan to Bangalore.
Bangalore, my lord.
Hassan to Bangalore. It is submitted that the distance between the places is how much? 180 kilometers. Kilometers, and it's difficult for the wife to travel. Considering the same stay, like in the other matter, hand summons.
Please.
25
Yes.
48
Next.
Cell number 18. Petitioner.
Happening for petitioner. Wife petition, my lordship, seeking a transfer from Bangalore to Nanjangud, my lord.
Nanjangud. What is the distance?
It is about 170 kilometers.
CC of which year?
My lordship, 24.
Said 180 kilometers.
170 kilometers.
Bangalore to Nanjangud.
Nanjangud.
The present petition is filed by the wife seeking transfer of MC number so and so from Bangalore to Nanjangud. It is submitted that the wife is staying at Nanjangud and the distance is about 170 kilometers. And considering the difficulties that are being faced by the wife, there shall be stay of all further proceedings. Hand summons.
My lordship, the problem is this. He is at Dubai, my lordship. He is represented by a council in other proceedings.
What I'm saying.
Yeah,
Hand summons on the council.
I can.
Yes. Next.
Council.
Yes. Call.
List number 3. Serial number 1. D. Narayan Shetty for appellant.
Yes, next. Let it be passed over to.
Serial number 2.
Yes.
Ravi S. Sampriti for appellant. Soumya Lakshmi Bhatt.
Next.
Well, I am for respondent and in one case.
No, he is not here. Next 3. Mr. Gowda. Mr. Gowda.
Is it passover or date is given?
Passover.
Passover, sir.
It is only for quantification, my lord. It is only quantification.
Yes, we will see. Yes.
Serial number 3.
Insurance company appeal
Shivanya
challenging
Gowda,
the liability on the
Gowda.
ground there is no policy on the date of accident.
Well, how is it dealt with by the court? Give the
Please.
file.
Para 14 of the judgment.
Para 14.
14 of the judgment. As far as the liability is concerned, insurance company has given the evidence that they have not issued a policy in respect of offending vehicle, wherein they have directed to file a specific affidavit before the court that they have not issued any cover note to the vehicle. Because during the course of evidence, a Xerox copy of the cover note was confronted to the witness bearing number so. Thereby, the court has directed the insurance to file a specific affidavit to that.
Yes. What do you say?
They have filed a claim petition before the court. They have not mentioned the vehicle number or the policy number or the cover note. We filed the affidavit to the petition stating that we have not issued any policy to the vehicle. And that circumstances, the petitioner advocate have shown the Xerox copy. It is not marked, not produced before the court. Basing on the Xerox copy, which was not marked, court has directed me to file an affidavit. We have already filed the affidavit stating that I have not issued the policy. They have not come forward with where they have taken that policy or the cover note.
Thereby, the court directed the insurance company to file a specific affidavit to the effect that they have not issued any such cover note to the vehicle. The insurance company has failed to file such specific affidavit. During the course of cross-examination, he has reposed that he cannot say as to which branch. Now, when the court gives a specific direction, you have to follow that.
I have filed the affidavit. I have already filed the affidavit stating that I have not issued a policy.
When the court is asking you to file an affidavit once again, what is your difficulty? That presupposes that, and in evidence you say it might have been given by somebody else, not by my branch.
Like that, my lord. The problem is like this. The document was not marked. On what basis I have to produce?
Let him come inform Mr. Karegoda.
Please.
Yes, next.
Serial number 4. Narendra
Where
Gowda.
both the parties are ready?
My lord, like Ravi Samprati is present, my lord. Ravi Samprati is present in serial number 2.
Like, right from online, he's able to say what's happening in the court. Yes, call that.
The,
Huh? No, they are ready with this is matter. 2 and 2.1. Yes.
Yes.
It's only on quantum.
No, this is on liability. My lord, there are two defenses of the insurance company. One
There
is
are?
two defense. One is the petition is not maintainable before the motor accident criminal in view of bar under section 53 of the ESA Act. He has admitted he has obtained he has secured compensation.
Under ESA Act.
Yes, so that is not maintainable. That is the first question. And the second thing is that the driver was not holding he had a license which was issued by Calcutta, and there we produced an acknowledgement having it states that no such license is issued.
Issued by them.
Calcutta, the RTO says we have not issued such license, and he has renewed that license in Bangalore, producing that license.
And what is the finding of the court on these two aspects?
my lord, that is page number 14, my lord. Actually, one submission, if my lord permits, I want to make only one submission.
Finding, you can tell, we'll read the.
It's already 10, my lord. It rejects both the finding. I'll just read out. It is one paragraph. The petitioner contends that the accident caused due to the negligence on the part of the driver of the car, which is owned by the second respondent, insured with the respondent number 1. Hence, both the respondents are liable to pay compensation to the petitioner. On the contrary, respondent number 1, insurance company authorities contend that as per the endorsement issued by Alipur RTO Exhibit R5, it shows that the license of the car driver is a fake license. On perusal of Exhibit R5, it shows that the insurance company official filed an application for obtaining the deal. On that letter, RTO Alipur authorities said that not found. On that basis, respondent number 1 contend that the license is a fake license. But as per the version of RW1, who is the owner of the car, produced the DL of the driver as per Exhibit R1 and Exhibit R2 policy and Exhibit R3 so and so issued by the Transport Authority, RTO Office, Bangalore. So, according to the version of the owner, the vehicle DL was renewed at Bangalore, even though it obtained at Alipur. So, naturally, when the DL is renewed at Bangalore, then the entire records of Alipur are to be transferred to Bangalore office. Naturally, there is no record at Alipur. Moreover, merely the endorsement of Exhibit R5, records were not found. It does not mean that the driver was not holding DL. Though respondent number 1, insurance company authorities have taken sufficient steps to inquire RTO Alipur, but who does not turn up merely on the ground, it cannot be said that the driver was not holding DL. Moreover, when the RTO authority is renewing the license, then must be verified the driver. So, the naturally presumption of the competent authority after verifying the same have issued the license at Exhibit R1. This is what the finding of the court. Because what happened was, as a usual practice, the insurance company has appointed an investigator who went to Alipur RTO to find out whether such a driving license is issued. They did not give any endorsement in their letter or otherwise. They only have stated, as per Exhibit R1, not found. The contention of that, the license which is issued at Alipur RTO is a fake one. That is not the license. And he has produced that license before the Bangalore RTO authorities. It is renewed.
That's one aspect on driving license. The second one is?
Second one, there is no discussion on that.
What is the other contention you said?
53, section 53 of the ESI Act is a bar.
No discussion.
But he has admitted in the cross-examination that he has availed the benefit under ESI. There is no finding.
Yes, Mr. Shastri, what do you say?
As far as the driving license is concerned,
not driving license, about availing the benefit under the ESI Act.
That is covered by this honorable court judgment. In a several judgment, ESI coverage that may be deducted, but Motor Vehicle Act is entirely different from ESI Act.
Which is the judgment?
This contention is not
taken. Act itself, why couldn't there be a judgment? Last time I am told that this is pending before the Supreme Court.
I have no idea. But 53 is
My
a
lord,
bar.
actually, this honorable court held.
The act
In
itself
fact,
says,
yes. My lord, the judgment of the Honorable Supreme Court in Tehran versus Associated
please,
Agencies.
pass on the judgment. We'll continue this matter after
My lord,
lunch.
my lord, one submission, my lord. After hearing all these aspects, my lord, earlier bench permitted me to withdraw part of the award amount. My lord, repeat, it is
No, you
only
are not before the earlier bench, you are before this bench. So
Yes,
what is the
yes.
order that is going to be passed by this court is based on your judgments.
My lord, ESI Act, my lord, it is covered by the judgment. My lord, I don't think.
Tell the court which is the judgment.
My
And
lord,
tell them to pass it on.
my lord, kindly have it
against
tomorrow, my lord.
somebody.
My lord, kindly have it tomorrow, my lord, because I have list of.
This matter as part of tomorrow.
Second list, serial number 6,
Huh.
await notice.
Yes.
With your honor's kind leave,
Yes.
I have got serious cough problem. So if your lordship could accommodate last 20th matter, at least for 4 or 5 days. So just
Which one?
serial number 20.
In which list?
This third list only. Third list only.
B.S. Umesh.
Yes. Yesterday only I am discharged from hospital. I have got some serious.
This is matter after 2 weeks.
Yes, much obliged.
At the request of learned counsel appearing for the respondent.
Much obliged.
Court officer? Court officer? Court officer? Court officer? ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ಸ್ವಲ್ಪ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾನು ಇದು ಮಾಡಿ ILR 1998.
ಸರ್ ನೀವು ಕಾಪಿ ಕೊಡಿ.
ILR 1998 ಕರ್ನಾಟಕ 2487.
ಸರ್ ಕಾಪಿ ಫರ್ನಿಶ್ ಮಾಡಿ ಸರ್. ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ ಕಾಪಿ ಫರ್ನಿಶ್ ಮಾಡಕ್ ಹೇಳಿ ಅಂತ.
ಅದಾಯ್ತು. ಈಗ ಇದನ್ನ ನೀವು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾ ಸಾಧ್ಯ ಆದ್ರೆ ಮುಟ್ಟಿಸ್ತೇನೆ. ಯಾಕಂದ್ರೆ ನಾವು ಇಲ್ಲಿ ಕಳಿಸುವಂಗಿಲ್ವಲ್ಲ, ನಾ ದೂರ ಇದ್ದೇನೆ.
ಸೈಟೇಷನ್ ಕಾಪಿ ಕಳಿಸ್ಬಿಡಿ ಹೇಳಿ.
ಅದೇ ಹೆಂಗ್ ಕಳ್ಸೋದು? ಅದೇ ಆ ಪ್ರಾವಿಷನ್ ಇಲ್ವಲ್ಲ, ಅದಕ್ಕಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ILR 1998 ಕರ್ನಾಟಕ 2487.
ILR
1998 ಕರ್ನಾಟಕ 2487. 2487. ಸರಿ.
ಮೇಡಮ್ ಅದು ಈಗ ನಡೀತೈತಲ್ಲ ಕೊಡಿ, ನಾಳೆ ಬರ್ಸ್ಕೊಡ್ತೀನಿ.
ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಹಲೋ ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಮೇಡಮ್ ಹೇಳಿ, ನಿಧಾನಕ್ಕೆ ಹೇಳಿ.
ಲಿಸ್ಟ್ ನಂಬರ್ 4, 5 ಅಲ್ಲ 4, 5, 6 ಅಂತ ಇದೆಯಲ್ಲ 4 o'clock. ಅವನ್ನ ಈಚ್ ನಂಬರ್ ಕರೀತಾರ ಹೇಗಮ್ಮ? ಯಾಕೆ ಅದು ಇಲ್ಲ ರೆಫರ್ ಮಾಡ್ಬಿಡ್ತಾರ?
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ಅದನ್ನ ನಾನು ಐ ಹ್ಯಾವ್ ಟು ವೇಟ್ ಅಂಡ್ ಸಿ ವಾಟ್ ಆಸ್ ಗೋಯಿಂಗ್ ಇನ್ ದಿ ಇದು ಆರ್ಡರ್ ಏನಾಗುತ್ತೆ ಅಂತ. ನಾವು ವಿ ಆರ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಐಡಿಯಾ ಅಬೌಟ್ ಇಟ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಏನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ ಅಂತ ನಾನು ಹೆಂಗ್ ಹೇಳಕ್ಕಾಗುತ್ತೆ
ಮೇಡಮ್?
ತಗೊಳಪ್ಪ ಇದು ಸೈನ್ ಗಿಡ ಸರ್. ಹಿಸ್ಟ್ರಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 4.
14 ಇದೆ ಸರ್. ಎಷ್ಟಲ್ಲಿ ಇದೆ? ಇವ್ರ ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ, ಒಂದು ಆಗಿಲ್ಲ ಲಿಸ್ಟ್ ನಲ್ಲಿ.
ಸರಿ.
ಅದೇನಾಗಿದೆಯಪ್ಪ ಎಲ್ಲ ಸುಮ್ಮನೆ ನೋಡು ಅಲ್ಲಿ ನೋಡು ನಾವೇನು ಮುಟ್ಟಿಲ್ಲ ಅಂದ್ರೂ ವಿಡಿಯೋ ಆ ಅಡ್ವೊಕೇಟ್ ಇವಾಗ ಹೇಳಿದ್ರಿ ಈಗ ಮಾತಾಡ್ ನೋಡಿ ಮಾತಾಡಿದ್ರಲ್ಲ ಅವರು ಯಾಕಂದ್ರೆ 1 minute ಆಗುತ್ತೆ. Why it is automatically muted the video and audio without we are not operating it at all. Why it is
ಇದು ಎಲ್ಲಿ ಬರ್ಕೊಟ್ರಪ್ಪ ಇದು?
ಯಾರು ಮಾಡ್ತಾರೆ ಅದನ್ನ ನೋಡಿಪ್ಪ ನಿಮ್ಮಲ್ಲಿ ಯಾರು
ಬರ್ಕೊಟ್ರು ಅಂದ್ರಲ್ಲ ಎಲ್ಲಿ?
ಮೇಡಮ್ ಅದೇ ಏನಕ್ಕೆ ಆಫ್ ಆಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ. ಈಗ ಇಲ್ಲಿ ಆಫ್ ಆದ ತಕ್ಷಣ ಅಡ್ವೊಕೇಟ್ಸ್ ತುಂಬಾ ಈ ತರ ನೋಡಿ ಹಿಂಗೆ ಆದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಏನಾದ್ರು ಸ್ವಲ್ಪ ಅದನ್ನ ನಮ್ಗೆ ಇದು ಅಂದ್ರೆ ಯಾಕೆ ಹಂಗ ಆಗ್ತಾ ಇದೆ ಫ್ಲಕ್ಚುಯೇಷನ್?